mentioning on the list? Any mentioning in the list? Item number 1, TRM NDPS 12/24.
I want the respondent. I'm appealing for the petition.
Yes.
The application for bail, they are in judicial custody petition, so case ID is required. Case ID is only called for. They have to two more matters which is for me.
Very well. The petitioner is in jail custody. Stuff. Let the case diary be called for. Stuff. List on Friday.
Yes, yes.
Day after tomorrow is Thursday.
Friday, lawsuits.
Friday, 15th. আরে এখানে ডেটটা চেঞ্জ হয়ে গেছে yes 14th 13th
Yes.
Sunday. Get reported. My lord, there was a direction, my lord, upon the administration and the central administration to file a report. I'm handing over the report now. Giving copies.
yes what is the
Not the-
status
Status, my lord, may I just read this now? In pursuance to the directions. Sir, के लिए वो copy रहा था. In pursuance to the direction. The government of India with letter dated 26/2024. Administration has taken up and a communication dated December 24 has been sent to the Registrar General Calcutta High Court, communicating the matter and requested that the same be addressed to the Honorable Chief Justice, Chairman of the Selection Committee constituted under Rule 6(1) for convening a meeting of the Selection Committee for initiating the procedure for appointment of President and members of District Commission. As per amendments made in the Consumer Protection Act, process for appointment of President requires written examination. DCDRC requires the process of appointment of President and members may take at least 6 months is only tentative because eventually if my lord will see the next letter, the next document, which is a letter dated 26 November 2024 issued by the Government of India Ministry of Consumer Affairs, Food and Public Distribution. My lord will see the second para. In this regard, attention of the state government's UT administration is invited to Honorable Apex Court's judgment dated 7 March 2023 in civil appeal. Honorable Apex Court was pleased to relax the requirement of holding written examination viva voce in the term. This is concerning the State Commission. Now kindly see the next page. Although the matter relating to process of appointment of members of the State Commission, President and members in the District Commission is pending for consideration before Honorable Supreme Court. As of now, Rule 6(9) procedure of appointment of which provides for written examination viva voce is operative. Additionally, Section 32 of Consumer Protection Act empowers state government to fill up vacancies in office of President and members of District Commission by way of directing any other District Commission to exercise jurisdiction in respect. So, my lord, so far as District Commission is concerned, written examination is required. Now, kindly see this letter addressed to the Registrar General, my lord, on the next page.
no it is all right the paragraph 3 you read out
Yes, my
that the president and members of the other district commission can exercise jurisdiction in this UT of Andaman and Nicobar. Is there any other district
No,
commission that is
no.
functional?
No, my lord.
And how will the district commission
my lord,
continue in
yes,
the
madam. So
inter-exam?
the issue, there is a committee. Kindly see the next document, my lord. We see 5th December 2024.
Yes.
This is regarding the appointment of members, president and members in district commission. In this regard, your kind attention is invited to resolution of video conference meeting held on 27th August 24 under chairmanship of Honorable Justice Shobhujaji Bhattacharya, chairperson of selection committee along with Secretary General Administration, wherein it was resolved that as such this committee feels it appropriate to await the outcome of the pending issues in the matters before Supreme Court and the appointment of President of State Commission before taking decision on future course of action regarding constitution of District Commission. Hence, the committee resolves that the learned registrar shall place the minutes of the present meeting before the Honorable the Chief Justice and shall inform the committee as and when final order is passed. Now, despite this Honorable Court, my lord, on the judicial side, it is submitted that a writ petition application WPAP 9 of 2024 dated 8 November 2024, this is the same matter, was filed, and my lord, this order, which was pronounced on the last date, on the last occasion, before the earlier circuit bench, it is just today in morning informed that this court received an administrative communication from Chief Justice as regard inviting application for appointment to President of State Dispute Commission. This court reasonably assumes that terms and conditions of appointment must also have been finalized. If that being the position, there should be no hindrance for appointment of President and members of CDRC, Fort Blair. Let affidavit be filed. Further reference is invited to 26 November 2024 received, wherein it is mentioned that this, I am not reading it again, since in the last meeting of the selection committee, it was resolved to await the outcome, pending issues, uh, before the an appointment of such and such. However, taking cognizance of the letter received from Ministry of Consumer Affairs, it is requested that a meeting of selection committee may be convened at the earliest for initiating procedures for appointment of president and members of DCEDRC. So in view of this, earlier the selection committee had given the opinion that the process should await the outcome of the Supreme Court proceedings. However, on the last occasion, the Honorable Bench presided by Honorable Justice Rajashekar Manthal said that you did not await that, in a sense that that's the administrative decision of the selection committee. Rehearsed that the Honorable Court, sitting on the judicial side, said that since already some letter has been received from the Chief Justice regarding further steps for selection of the State Commission, so why should steps also be taken for the District Commission? So therefore, we have written to the selection committee now, and it is in the hands of the High Court on the administrative side.
Tell me what will be the process in the interregnum?
That's what, Your Lordship, I have been insisting for an ad hoc arrangement. That should be done.
Something. Where will the litigants go? The consumers go? Will they be remedialist?
2.5 years.
Be.
And the High Court, perhaps the High Court is on the administrative side can look into the matter, because my lord, High Court is represented, I think, with the council.
Your Lordship, the entire government is running. Half of the posts are on ad hoc basis. We all know about it.
How can the
Page 16.
Why can't it be?
1 minute,
Page
please.
16.
Of
Status report filed by.
central government is also filed status report? That's
This is, my lord, what happened on 3rd of March,
please.
on 3rd of March 2023, the apex court passed an order, the direction whereby it has made mandatory that there should be written examination of, this is the mandatory.
No, it is all right.
Admitted.
Whatever is the procedure.
That has to be followed.
My lord, what happened? Thereafter, the interim application was filed. Interim application filed for amendment in the Supreme Court. This is at page 12, my lord. Kindly come to page 15, my lord. This is the proposed at para 3, my lord. Proposed amendment. Para 16. Page 16. Para 3, 1. The selection committee headed by the Chief Justice of the High Court and its nominee may be permitted to determine its own procedure for making its recommendation, keeping in view of the specific requirement of the State Consumer Forum on this acquisition, number of vacancy, number of applications, and after taking into the account the suitability of the record and the past performance, integrity, and so far as the application is concerned, for the President and the State Commission, the District Commission may be exempted from the written test as in Rule 6(9), and the remaining portion, the selection committee may be permitted to determine its own procedure for making its recommendation, keeping in view of the requirement of the State Commission of the District Commission after taking into account the suitability, record, and the past performance, integrity, and the adjudicating experience of the person concerned. Amendment is also in composition of the selection commission to selection committee to include the president of the state committee, the selection committee, and the.
This is still at the proposal state.
My lord, this has to, the permission, it has been permitted, my lord.
It has been permitted.
Like next para 4, my lord.
Yes.
During the course of the hearing, it has been considered by both the sides that no written test would be required. Feasible and practical for the appointment of the state commission, which a former judge of High Court is required to be there. Therefore, we direct that the requirement of holding a written examination is relaxed.
President of the
Only for the president of the state
what
commission.
the district?
District Commission, my lord, written examination has to be held.
Yes, yes, yes. Even I am submitting written examination has to be
No,
held.
may I just,
The last-
may I just,
Ad hoc arrangement
may I
has
just
to be
explain, my
made.
lord? I think
Happening
we
in
have,
the other states.
no, my lord, what I'm submitting is, there is, before the Supreme Court, it is.
Continue. All this continue.
In the Supreme.
That arrangement is made.
My
Why
lord,
they are not doing
I
it?
appreciate the situation, my lord. So far as state commission is concerned, Supreme Court has a written examination, retired honorable High Court judge. So far as district commission is concerned, written examination is to be held.
Yes.
The selection committee passed a resolution that nothing should be done until the Supreme Court decides the issue. Then the matter came up before this honorable court. This honorable court said that since my lord will see the last order, it records that some advertisement has been received for appointment of the president. So honorable court said that find out what is the status regarding this district commission. So my lord, we have filed this, we have written to the selection committee, which is chaired by honorable sitting judge of the honorable High Court, that my lord may if either further guidance may be given, my lord. The government has very little because before the High Court in its administrative side, my lord, what can we do in this situation, my lord?
They have to make some alternative arrangements. There are methods.
Election
No, you are aware of the methods. You are doing so many methods.
Election committee-
You are arguing that way.
This is
No, selection committee,
No, my lord.
selection committee is only in respect of regular appointments, sir.
this is.
Ad hoc arrangements can be made
I
everywhere.
completely agree, but that has.
That modalities have to be worked out.
Wait a second, that guidance has to come from the administrative supervisory authority.
For
which is
that
the
reason,
High Court.
they have come to the court.
No, of course.
If they are not taking any step, the court will give a direction for that.
Of course.
Let the committee take a decision and
The committee.
So in this, some arrangement can always be made.
What ad hoc arrangement you mean for?
What I am submitting that
Do you-
either, there are two methods. Either the old members who are already there, they may continue till the regular selection takes place, or else for ad hoc arrangement also, they can immediately start the method of appointment which was there earlier. That method can be followed and some ad hoc arrangement can be made. They are saying 6 months will take more. That means 2 years have already gone.
More also, it is
Yes,
tentative.
no,
We are not enough
tentative.
same.
In that case, ad hoc arrangement has to be made with them.
My lord may then consider.
There may be a direction to the authorities
The selection.
to find the authorities for
Cannot,
the purpose.
not authorities.
Yes, yes,
Request.
and I am not saying, I am saying selection committees are also authorities.
Yes, yes, absolutely.
It's not that they are not authorities, they are also authorities.
See, they are much higher than.
Supervision is functioning.
No, it's not.
That's not functioning. Yes.
My lord, there is a selection committee headed by a sitting honorable judge. Let the selection committee be requested to find out a modality in the meantime. No problem.
Everywhere it is done, everywhere.
नहीं होता जो
Let this committee take a decision. Let the committee take a decision. Please come.
I am told my lord, my learned colleague is pointing out that the situation is like that in Kolkata also. I don't know, saying that the members are running this thing because of the Supreme Court pendency.
Members are?
Their members sit over there. There is no president. Even in Calcutta, Unit 1, Unit 2, which I present at Esplanade or Rajarat Consumer Forum, District Commission Forum, I go over there. So even there, no presidents are there. And even where there
The members are there
members are there, certain members.
and they are continuing with the work.
And they generally don't pass any effective order because
Yes,
they don't.
they cannot.
They cannot pass any effective
Right.
order. That is in Consumer Forum Act only.
But then the procedural part they can take care of. At least the filing, the objections from the other side. Yes,
that
can
can
be,
Those things can be completed within this particular year.
hearing
In any case, my lord, there's no negative equality. If today my lord feels.
It's all right.
It's definitely something positive, my lord, can happen. It's not that.
Uh,
But my only request is
Sign this report.
this is my lord signed by the registrar of the State Consumer Disputes Redressal.
All right.
So my only request is, my lord, may please bear with me on this. My only request is, my lord, there is a selection committee. Selection committee can be requested to work out a.
Yes.
interim.
Yes, yes, I'm also saying that.
The report filed by the registrar, State Consumer Disputes Redressal Commission and the report by the report on behalf of the Union of India are taken on record. Stop. It has been brought to the notice of the court that the selection committee constituted for the purpose of finding out the modalities for appointment of the president and the members of the district commission is in active consideration before the committee under the chairmanship of an honorable judge of this court. Stop. Paragraph. The issue of appointment of president and members of the commission is still pending consideration before the Honorable Supreme Court. Paragraph. It is more than 2 years that the consumer forum, that the district consumer forum in the islands is non-functional. Stop. The litigants cannot be left without any remedy. Stop. Paragraph. It appears that the process of appointment of the president and members of the commission may take some time. Stop. Next. In such a situation, the committee is requested to find out a method so that an ad hoc interim arrangement may be made for functioning of the District Consumer Redressal Commission. Stop. The Honorable Committee may be apprised of the aforesaid fact, and it is expected that the Honorable Committee will be able to find out an interim arrangement to resolve the issue. Stop. Let the matter appear in the list for the month of February 2025.
Yes. Apply.
Item number 3, CRA 5/2024.
Well, in this matter, Mr. Alok sir is appearing for the appellant. The service has not been effected. Let it be posted to next circuit.
Learned advocate appearing for the appellant submits that service is not complete. Stop. Prayer has been made for adjourning the matter till the next circuit. Stop. On such prayer, list the matter in the next circuit. Service in the meantime.
Item number 4, SAT 16/2024.
Lordship, in this matter, I am for the appellant. This is a second appeal against the order of the London District Judge. Along with the main application, there is a CAN application also. There is a delay of 30 days, Lordship. In this,
Did you serve?
after notice only, Lordship. After admission only.
There is delay application.
Come after service.
Lordship.
The appeal has been filed beyond the period of beyond the prescribed period of limitation. Stop. Paragraph. Let copy of the application be served upon the respondents. List in the next circuit.
Grateful, Lordship.
Example 5, DCT 17 of 2024.
The first hurdle of 100 CPC is to be crossed. It's for admission under Order 41 Rule 11. Lordship. I have
Consent
proposed a
order.
substantial question of law within the ground of memo.
Consent order,
It's not a consent order.
not a consent.
No,
order.
no.
Okay,
No, what has happened? No, I'm a squatter. As an encroacher, certain rights are recognized in these islands under the local regulation. One of such provision is Regulation 202. If the revenue department wants to evict me from the land, the proper and the solitary course would be to pass an order under Regulation 2021. And if that order is passed, then that gives me a right to establish my right over the subject land in a civil suit under 2027. This is a case where, Lordship, without due process of law, attempts are being made to dispossess me. Immediately a suit was filed before the trial court seeking simpliciter possessory right. Don't evict me, you do it, but in accordance with law. The trial court went under different premises. The trial court treated my suit to be one seeking adverse possession. And applying the principle of Gurdwara Sahib case, because at that point of time, Lordship, I cannot file a suit. At best, I can protect my possession. Now that judgment has been overruled by the Grewal judgment. Now I can take the plea, I can file a suit seeking my right. And the first appellate court simply affirmed it. This is a question of law to be gone into, Lord, for which the second appeal has been taken out. I have, within the memo, Lordship, I have proposed the substantial question of law. I can take one to the trial court's judgment as well as the first appellate court judgment. These are the findings arrived at by the trial court, which was affirmed by the first appellate court.
what is the finding of the trial court?
Trial court's finding, my lord, I have not paginated certified copy.
Yes.
Lord, I'll take to the judgment of the trial court. It's at page 9. Page 9 of the trial court judgment dated 30th of January 2019. Page 9.
Yes, paragraph. Yes, it was.
Second paragraph. The trial court applied the principle of Gurdwara Sahib case. But my suit was not for adverse possession, Lordship. My primary prayer was to seek a declaration seeking protection of my possession. The Tahsildar has a right to evict me in accordance with it. That was my case. On a fateful day, Lordship, without any notice, nothing, the defendants have entered into the suit land to throw me out of the suit land.
You annex the copy of the suit for declaration, the decree.
Trial court's judgment decree, first separate court's judgment. These
This
two documents,
mentioned decree declaring possessory right, title, interest of the plaintiff of the suit.
my lord.
The decree declaring defendant over right, title, interest of the suit stand extinguished.
That's a prayer which has been reproduced in the decree. Now, my
Yes.
primary prayer is declared as the possessory
Temporary
right
restriction,
and a permanent injunction.
register the.
And in the written statement, they have admitted my possession. They take a different period for my possession, but the possession as regards my client is admitted. And in a possessory suit, sine qua non is possession, my lord.
The clear suit for declaration of title.
No, title I have not claimed, my lord. My primary relief was in the
Right, title, interest.
No, it's a second prayer. My primary prayer is possessory right.
Because not knows under order 2, rule 2, I can take 2 pleas in a suit. One, based on the facts stated in the claim, the court can grant any one of the relief. There is no bar under order 2, rule 2. I can take 2 inconsistent pleas.
Peaceful possession of suit land involving temporary restraint, defendant is not the district possession. Picture over a property based on adverse possession.
And the suit land is 50 square meter government revenue. I'm residing there. There is a dwelling house. I'm residing allows me families membership documents were placed. In a such nature of suit ownership, normally the decree is in such a form that possessory right is perfected with due process, you can evict it. That's the decree which needs to be passed in every suit of such nature.
I put when the district judge has gone into details. Second one has issue got any right title and possessory right over the suit property is claimed by him. Possessory right being yes. The appeal court's order you see. He's seeking possessory right. There is no document on the side of the claim that he's residing over there in the Swiss property. The court has gone into it. Yes, yes, submitting in case of possession, the land and claim is possession. Possessory rights, the appellate court has gone into it. The appellate is claiming his possession, but he has not filed any document in support of the clear then the title is just
As per the law point and all that.
whether possessory rights.
Both sides decided for this. Which I not. This is related to your first permission. We are not. That. But we are not. That together your first permission is.
No, but it's not only the case, the facts are taken into consideration. He's residing,
That's very interesting question.
not only there is a residing, it's taken into consideration everything. No document that is in possession is not exactly. Possessions are refused as concerned. Not reading the right directive. It can be residing on. Actually. Please, they think that it's coming to it. 47 years, calculated and it appears to be 10 or 11 years. It's the person, everything.
In a suit for adverse possession, the frame of the suit, the pleadings, the prayer would be distinct from that of a suit in simplicity or not kindly the prayer. It's a possessory right I claim.
The issue of your possession has been gone into details.
My lord.
Where is the question of law?
No, possession admitted. No,
Possession not admitted. The court has come to a finding that you are not in
but in
possession.
the written statement, my lord, kindly look into the written statement filed by the authorities before the trial court. My possession has been admitted, but they give a different period of my possession. I say one time, they say different time. But my possession has been admitted in the written. But this is where the trial court as well as the first appellate court went wrong. Not entire issues are framed based on pleadings. No, issues under Article 14 are framed based on pleadings. I have said that I am in possession. That has been admitted. The period of possession is different. That issue ought to have been framed in that line. But the trial court came to a conclusion beyond the pleadings. It was nobody's case, my lord. It was nobody's case. I'm not kindly. I'm having the written statement with
They are
me.
not pleading.
No, I'm just having the one copy because memo I can't annex these papers. Memo, my lordship, just these two document judgments.
We are required to go through.
I can bring a compilation tomorrow or day after, as my lord pleases, my lordship. Compilation of the pleadings of the trial court.
I do not find at least any point of law without over here. Will you get time? And how is it possible?
My lord, let me persuade my lord with the my lord, kindly see the pleading, not civil suit, not most. Based purely on pleadings.
Yes.
Everything is based on pleadings and document. As it's a well-known saying, lordship.
Please come.
Man may like, but the document. I have placed entire documents.
Peruse the grounds set out in the memorandum of second appeal. Stop. We are prima facie not convinced with the points of law as framed therein. Stop. Next. Learned advocate representing the appellants seeks time to file a compilation annexing the pleadings placed before the learned trial court. Stop. Let the same be prepared. Stop. List in the next circuit.
Okay.
Try to convince the other court if it is possible. Prima facie is not convinced. Can't help, you can convince the honorable court with the pleadings and everything.
Item number 6, WPCT 234 of 2019. Pattern might not actually have.
2019.
I don't know, my lord, which
6-0.
department, but Mr. Kumar was for the petitioner, so maybe he can responded. Ms. Nag's name is showing perhaps because at that point of time she was appearing for the administrator. You can request her also.
There is an order of the Honorable Supreme Court application for exemption of the certified copy of the interim judgment allowed. Stay of
This
operation of
department might
the.
not appear.
How it appears first time after.
Is there a direction for rehearing or what?
Rehearing.
We have to.
Not may let it come in the next circuit. In the meantime, I will also communicate with Mr. Devedi will communicate to the police department.
Set aside the impugned order and restore the writ petition to its original number to be heard and decided afresh on its own merits, after affording opportunity of hearing to the parties. This is the appeal of the Union of India. Very well.
We'll take instructions. and let it
Come back
in the-
because everything is on record. This has to be heard afresh.
One error was there in division bench order. So I requested the honorable Supreme Court to decide it there itself. Instead of relegating the matter back.
And help.
You will get one opportunity.
Again, go over there. The matter has been remanded for fresh hearing by the Honorable Supreme Court. Let the matter appear in the next circuit. Stop. The parties shall come ready for hearing.
Not done, but- Huh? Rajesh, Rakesh, sir.
Item number 7. DRA DB 5 of 2023.
Respondent had sought time to file reply, opposition.
No, but I'm not intend to file any reply or because opposition, because I already get relief, got the relief. So I'm not file any reply.
Would you like to proceed with the
Yes.
case if your relief has already
Yes,
been?
I'm ready.
No, would you proceed? Or withdraw this application?
No, my lord.
The first one is yours.
My channel.
Oh, you have checked.
Yes.
FMT, yes.
They have also filed, so easy way. If I have to understand correctly, then second up, this MAT 19, the private party is seeking to withdraw.
No.
You said
Last
you
one,
received relief
last one.
meeting.
Last one.
WPA 186 of 2024, this is for execution that you are seeking to withdraw. Then that can be disposed of, my lord.
Already he has
1 minute.
received.
This is appeal.
Have you taken proper instructions? What you want to withdraw?
I'm not going to withdraw any application.
He will not file any opposition. You will not file any opposition.
Already, for what purpose? The appeal, which is filed by the appellant. I'm ready with the appeal,
For hearing of the
for
appeal.
hearing of the appeal, because,
Opposition being filed.
yes,
All right.
because there are two applications, one appeal and second one is interim application as sought by the appellant.
Interim application, is it can 1 of 2024 in connection with FMAT 1?
That has in effect become infructuous for the reason that
That I have withdrawn the,
there was a
deputy command.
direction as per the, my lord, honorable court's direction, we had deposited the amount. And that has been withdrawn.
withdrawn.
And the second matter, MAT 19 of 2024 has been filed by the private party seeking interest.
Yes,
And WPA 186 of 2024 has been filed for execution. That has become infructuous now because we have already got the money.
Already compliant.
let's start with the appeal you.
Yes, let him start.
Yes.
How long will the matter
It will
likely?
take some time, my lord.
In that case, we'll fix it in the next circuit
Yes.
because
It's a very small issue.
We see the order sheet he has taken, they have taken time.
Only
repeatedly.
substantial question will be arise before the, this honorable court.
They have received the money. They have repeatedly sought time. I was not.
you have got part remedy.
Full
Yes,
money
I
received.
received. Full-
Yes.
yes.
Full amount has been
What is the use of
urgencies and my.
the emergency in hearing the matter today?
Because these are small issues, your lordship. Only the point is that
See the order.
the
copy.
appellant says that, submit that the amount which was released, comes under severance compensation. Whereas I filed before this, under court below for seeking death compensation. So the moot question is before this, honorable court, whether it comes under severance compensation or it comes under death compensation. So it's a very simple issue.
Not a-
Yes, simple issue,
The money that.
but then it will take some time. Fix it in the
And
next.
they had
Please
sought
come.
time for reply. Let it be recorded. They don't want to file opposition.
Learned advocate representing the respondent number 1 submits that opposition will not be filed in the application for stay. Stop. Let the appeal be taken up for consideration in the next circuit.
Here there is a death conference.
That he has already received, but under which head it will be, it has to be decided.
What does it matter? Severance compensation. You already received such. Then
Item 11, committee article 2
Mr. Rajesh Kumar is for the appellant in this matter. My lord. He requested me to take next circuit in this matter, my lord.
I am for the respondent.
What is
It was a
it?
ready matter, but unfortunately it could never reach till date.
Very well. On the prayer of the learned advocate representing the appellant, let the appeal be placed for hearing in the next circuit.
Right.
My appeal, my lord.
I am appearing for the response.
I'm ready, my lord. Take some time.
I don't think it will take any time.
Very well, no difficulty. No, I'm ready.
Only discrimination, that's all. Already the code,
Paper book is there, my lord. Kindly have the impugned order, which is at page 247 and begins. Once I'll go through the impugned order and then refer to the pages because my lord,
227,
247.
47. Yes.
The petitioners are aggrieved by an order dated March 13, 2020, granting regularization to the petitioner because they were seeking more relief. Learned advocate appearing for the petitioner submits that the petitioners were working as daily rated Mazdoors. Petitioners approached a writ court which, with such proceedings was ultimately disposed of in favor of the petitioners. He submits that employments of the petitioners were directed to be regularized. Pursuant to such direction of the High Court, the administration came out with an impugned order dated March 13, 2020. Now, my lord can, for a moment, my lord, come to page 146. Then my lord will, so that my lord, the impugned order before the writ court can be placed. Kindly have page 146. This is office order number 255, which is 13 March 2020. The director IP&T is pleased to appoint following 29 persons on supernumerary post of workmen with effect from 21st November 2019 in the level 1 of 18,000 to 56,900 in Directorate of IP&T as per Ministry of Tourism order dated 21st November 2019 and in compliance of Honorable High Court's order dated 27th August 2019 and with approval of Ministry of Home Affairs subject to the following terms and conditions. Now, kindly see various this terms and conditions are not as such relevant. What is relevant is this regular appointment is granted from 21st November 2019. That is the only relevant fact in this order. Now, if my lord comes back to the impugned order, page 247, he submits that the petitioners were regularized with effect from 21st November 2019 rather than from the date of their initial appointment. Petitioners were not afforded regular further benefits such as pensionary benefits and other benefits that a regular employee is entitled to in law. He draws the attention of the court to an order bearing number 298 dated 8 December 2009 passed by the administration with regard to home guards. Now kindly have page 198. Which is this order passed in the context of home guards with whom the writ petitioner sought parity. Kindly have page 198. This is an order of the Commandant Home Guard dated 8 December 2009 in compliance to the ANN Administration's order dated 3rd November 2009. Approval conveyed by Government of India Ministry of Home Affairs. Video such and such dated 9 September 2009, judgment and orders dated 6 May 2009, passed by Supreme Court in SLP Civil 10496 and dated 22nd January 2007, passed by Honorable High Court in March 25 of 2006, following home guards and the similarly placed home guards of this ANN Home Guard organization are hereby regularized in supernumerary post in lowest group D grade from the dates of their respective initial deployment in A&N Home Guard organization. So this is the order passed in the context of the Home Guards. Now kindly come to minor 247 again. He submits that Home Guards were regularized from the dates of their respective initial deployment and were afforded financial benefits as enumerated in clause 3 of terms and conditions. He submits that similar benefits should be accorded to the writ petitioners as the writ petitioners are similarly circumstanced as that of the Home Guards. The learned advocate for administration submits that impugned order dated December 8, 2009 was passed. Here it's not impugned order, perhaps it's a clerical error. This is the order passed in the context of the Home Guards. It's not the impugned order. Was passed in compliance with the order dated 22nd January 2007, passed by the High Court in March 25 of 2006, and order dated such and such passed by Supreme Court, submits that the impugned order. Now kindly, before I come to that, kindly take this because they are seeking parity with the case of the Home Guards. So therefore, this order in the context of the Home Guards dated 8 December 2009 was passed in compliance with the order dated 22nd January 2007, passed by the division bench in March 25. Now, my lord, this order assumes a lot of significance because, my lord, the facts and circumstances in which the order in the case of Home Guards were passed, according to the humble submission of the appellant, is not at all at parity with that in the case of the writ petitioners. So kindly have page 177, which, my lord, is the order passed by the division bench, and why, in what circumstances, in the case of the Home Guards, the benefit was given from the date of their initial appointment. Kindly have page 177, my lord. This order, my lord, will be required to be placed in extenso. Kindly have page 177. In this appeal, this is an order of the division bench passed in the case of Parul Devnath. In this appeal, we are called upon to consider and or examine the scheme VIZ Home Guard Regularization Absorption Appointment of Andaman and Nicobar Administration 2005 to ascertain as to whether the said scheme was framed in conformity with the order passed by another division bench on 16 December 2003, heard analogously with this appearing at this page. By the said order, direction was given to the appropriate authority, that is, which is the Andaman and Nicobar Administration, to frame a scheme as per direction of the learned tribunal passed in its order dated 16 September 2002 in OA number 122 of 1999. The division bench also directed the concerned authority to take into consideration principles laid down by the Honorable Supreme Court in the case of State of West Bengal versus Pantha Chatterjee, reported in 2003 SCSLR 538 while framing such scheme. The said order of the division bench was challenged by official respondents before Honorable Supreme Court in special leave petition, being petition for special leave to appeal primarily on the ground that principles laid down in Pantha Chatterjee case cannot be applied to the case of the petitioners, as petitioners are not similarly situated with the petitioners in Pantha Chatterjee's case. The said SLP was dismissed, meaning thereby directions passed by division bench are required to be carried out. The scheme, which is Home Guard Regularization Absorption Appointment Scheme, was ultimately framed by the Andaman and Nicobar administration when administration was compelled to do so by an order passed in contempt proceedings initiated against administration official. Challenging the scheme, a writ petition was filed by the appellants, contending inter alia that the said scheme was not framed in conformity with direction passed by division bench of this court in earlier writ petition as aforesaid. The appellants prayed for issuance of mandamus for cancellation of said scheme and for absorption of the petitioners in terms of direction passed by the division bench in the earlier writ petition as mentioned above. By the order impugned, the learned trial judge rejected the said writ petition by inter alia holding that scheme was formulated by the authorities in accordance with decision of the division bench and also by following the directions passed by the Honorable Supreme Court in the case of State of West Bengal versus Pantha Chatterjee. The learned trial judge held that reservation of 20% of the vacancies occurring in every year, including existing vacancies in all the posts in Group D in ANN administration and in the post of constable in Group C under ANN Police Department, for home guards who are presently enrolled and have rendered at least 5 years of continuous service or more and fulfilling eligibility conditions, including education qualifications prescribed in the recruitment rules, Andaman and Nicobar Police Manual 1963, and the continuation of such reservation policy till the total absorption of the petitioners in service is just and equal as 100% reservation for the vacancy for the writ petitioners demanded by the writ petitioners cannot be accepted inasmuch as 100% reservation is opposed to public policy. The learned trial judge further held that if 100% reservation is provided for petitioners and the other candidates of reserved category uh, uh, will lose their right even to apply for such vacancies. Let us examine as to how the learned trial court was justified in arriving at such conclusion. In order to examine as to whether the scheme was framed as per direction of division bench in the earlier writ petition or not, this court is required to place on record the directions passed by the tribunal, which the authority was required to adhere to at the time of framing of the scheme in terms of the direction of division bench. The direction of the learned tribunal are as follows. The respondents, and in particular respondent number 1, shall consider framing an appropriate scheme in consultation with the ANN administration for absorption, regularization, appointment of persons like appellants who have been working as home guards for a number of years, and for connected matters. They shall also keep in view observations made in para 7 above while framing the scheme to sort local conditions, keeping in view particular facts and circumstances of this case. For the sake of convenience, para 7 of the order of the learned tribunal is set out below. It is recollected by one of us that the tribunal had considered a number of cases of home guards who have been employed by the government of NCT of Delhi, who had also claimed similar benefits and provisions of the relevant home guard rules applicable to Delhi. The same pleas that the home guard is a voluntary organization is not meant as full-time employment. There were no sanctioned posts, and therefore there cannot be any regularization of members of home guard were raised in those cases also. However, in furtherance to this, to the directions of the tribunal, writ petitions were filed by respondent government of NCT Delhi, in which certain directions have been given by Honorable Delhi High Court also to the respondents to prepare a scheme to cover home guard in certain situations. We consider that in the circumstances of the case, it would be appropriate for the respondents, and in particular respondent number 1, Union of India, to Ministry of Home Affairs, to contact the government of NCT Delhi together with relevant judgments of Honorable Delhi High Court and Tribunal on the subject, so that they can examine the issue raised in the present two applications in a similar fashion, prepare a scheme as per directions of the court to deal with similar issues which may in the circumstances be seen and considered, and if necessary modified to suit local conditions. Since the division bench, while disposing of the earlier writ petition, directed concerned authority to frame the scheme as per the aforesaid direction of the learned tribunal, also by taking into consideration principle laid down in the case of Pancho Chatterjee, we also think it necessary to set out the directions which were given upon the respondent herein in Pancho Chatterjee's case, which was also a case of home guards. Part-time members of border wing home guards should be treated as per at par with whole-time staff of the border wing home guards. They would get all the privileges on the state armed police as extended to a full-time border wing home guard. All benefits available to West Bengal government servants, for example, fixation of pay, benefits of PF, gratuity, rational benefits and allowances and leave, etc., shall also be made admissible to the petitioners. Arrears of service benefits were also directed to be given since the time of their joining. They were also directed to be absorbed irrespective of age bar which would stand waived. Let us now examine as to whether the concerned authority adhered to the said directions in framing the improved scheme. Kamaraz, I am skipping this. Kindly see on the next page. Mr. Ray, learned senior advocate appearing for the official respondents, submitted that impugn scheme was formulated in conformity with the direction of the learned tribunal. Mr. Ray further submitted that authorities were never directed by earlier division bench to frame the scheme in line of the directions passed by the Honorable Supreme Court in Pancho Chatterjee's case. Mr. Ray further contended the division bench, while disposing of the earlier writ petition, simply directed concerned authority to take into consideration principle laid down in Pancho Chatterjee's case at the time of framing of the scheme. Mr. Ray thus contended the said part of the direction cannot be considered as mandate on the part upon the authority to frame scheme by following principles laid down in Pancho Chatterjee's case. Mr. Ray further contended that since the petitioners were not similarly placed like the petitioners in Pancho Chatterjee's case, the principles laid down in Pancho Chatterjee's case cannot be followed here. We, however, are unable to accept the said contention of Mr. Ray, as contentions of the official respondents were not accepted by Supreme Court, Honorable Supreme Court in special leave petition. Mr. Ray further contends, since special leave petition was in limine, it cannot be held that contentions were not accepted. We cannot accept the said contention, as it is settled law. The order of dismissal of special leave petition limine merges with order challenged in SLP, and this order passed by Supreme Court is final and conclusive as far the parties are concerned. In view of the aforesaid decision, this court holds that the order which was passed by the Honorable Supreme Court and specially petition as referred to above determine the rights of the parties in all finality, and as such, the court cannot permit respondent to reopen issues. On careful consideration of the orders passed by the learned tribunal, earlier division bench and Honorable Supreme Court as aforesaid, we have no hesitation to hold that concerned authority is required to frame the scheme not only as per direction of tribunal, also in light of principles laid down in Pantho Chatterjee. If that be so, then we have no hesitation to hold that said directions were not followed by the concerned respondent while framing the impugned scheme. Neither the learned tribunal in its aforesaid order nor the Honorable Supreme Court Pantho Chatterjee's case directed the concerned authorities to frame a scheme for absorbing the petitioners in installments. Absorption means regularization of services. Absorption or regularization and new appointment are not synonymous. In case of new appointment, employer cannot ignore principles of reservation of schedule class, schedule type, OBC, etc. But in case of absorption, regulation, reservation policy is unknown. As such, we cannot agree with findings of the learned trial court that absorption of all the eligible petitioners amounts to 100% reservation. As a matter of fact, absorption of the eligible petitioners in installments by introducing reservation policy in respect of the existing vacancies and future vacancies was never contemplated by the learned tribunal or earlier division bench in the respective judgments. The spirit of the order of the learned tribunal as well as earlier division benches makes it clear that benefits given to the petition, the said order should be extended to all the petition uniformly and without making any discrimination amongst them. If the absorption is made in installments by introducing reservation policy in the matter as sought to be done in the impugned scheme, many of the eligible petitioners may not get the ultimate benefits of the order because of attainment of their age of superannuation even before their term for absorption matures. That apart, conjoined reading of the directions of the learned tribunal and the directions of the earlier division bench makes it clear that on absorption of the petitioners, they will get the entire benefits with effect from the date of their respective appointments, meaning thereby that the effect of such absorption will relate back to the date of their respective appointments. This aspect has not been taken into consideration by the administration. Furthermore, condition contained in clause B of the said scheme appears to us as contrary to spirit of Pantho Chatterjee's case. Similarly, directions contained in clause I thereof is not only contrary but is also discriminatory. The said clause provides that those who cannot be absorbed within this reservation policy before the age of 50 years will be entitled to daily allowance only at prescribed rate by competent authority from time to time. Thus, those who are eligible for absorption under the scheme but could not be absorbed due to non-availability of posts are treated differently. That apart, those who will be absorbed in service, they will remain in service up to the age of 60 years, while those who are unfortunate and whose service cannot be regularized will have to retire on attaining the age of 50 years. Such discrimination amongst equals is opposed to the principle of equality. Furthermore, there is nothing on record to show that observations made in para 7 have been taken care of. Under such circumstances, this court is unable to hold the impugned scheme was framed in conformity with the directives of earlier division bench of this court. The impugned scheme thus stands quashed. Now, this is very important, my lord, from here. The concerned authority is directed to frame scheme in conformity with the decision passed by the division bench in earlier petition. Before parting, we make it clear we do not find any unreasonableness in eligibility criteria. Mr. Ray, however, tried to impress upon this that sufficient number of vacant posts are not readily available. As such, the official respondents may be permitted to frame a suitable scheme for absorbing the petitioners in installment in the existing available vacant post as well as the post which will fall vacant subsequently by maintaining their seniority with reference to their respective date of engagement in voluntary service. Mr. Ray further contended that if all the petitioners are required to be absorbed at a time in the existing vacant posts in various departments of the administration, then the normal process of recruitment will be suspended totally, which may cause prejudice to various eligible candidates having general as well as reserved category. We cannot accept such suggestion of Mr. Ray, as we have already observed that such proposal is against the spirit of the judgment of the division bench. As such, the official respondents are required to find out the ways and means as to how the eligible petitioners and the other similarly placed persons can be absorbed on regularization of their service at a time. If, however, it is found that all the persons cannot be accommodated at a time in different departments and establishments of the administration, then the concerned respondent is required to create supernumerary posts so that the eligible petitioners can be accommodated in suitable posts at a time subject to satisfaction of eligibility criteria. Such posts, however, may be abolished on retirement and not termination of service. So, my lord, this was a case where, my lord, there was a long history of litigation. There was a mandamus to frame a scheme for absorption of these petitioners. That scheme was formulated in a way which was found to be discriminatory and not in accordance with the directions. When the matter was heard before the division bench, one of the arguments raised by the admin on behalf of the administration was that there are no sufficient vacant posts. In that light, the division bench said, well, if there are no sufficient vacant posts, then you create supernumerary posts where these people will be accommodated during as long as they serve, and after, as usual with supernumerary posts, after they retire, the posts get abolished. So it was in that context, but their service benefit was not contingent upon them being appointed to supernumerary posts. Their service benefit from the date of their initial appointment was contingent, was based on the earlier orders passed by the High Court, by this Honorable Court and the CAT, which required them to be regularized or absorbed in service from the date of their initial appointment. So, my lords, it was in this context, my lord, that the order dated 8 December 2009, with which the writ petitioners in this case have sought parity, was passed. Now, if my lord comes back to page 248, learned paragraph 2, learned the second para, sorry, learned advocate for the administration submits that impugned order dated March 13, 2020 was passed in consonance with the order number 1115 dated 22nd June 2021 of the financial year. So this appears to be an error, my lord, maybe an unintended, my lord. This is actually, this should be 21st November 2019, which is at page 234. Kindly have page 234. The order of the ministry, my lord. 21st November 2019, which is at page 234.
But then the order number is also different.
Yes, my lord. This appears to be, I think that is how I understood, subject to what Mr. Kumar.
Is there no existence of this
I
1115?
couldn't find, my lord.
All right.
Now, kindly see 21st November 2019 at page 234. Now, this is the background on which these supernumerary posts were created for these petitioners. Now, kindly see this order, page 234. This is being the order of the Government of India, Ministry of Tourism. This is being communicated in compliance of the Honorable High Court order, High Court Calcutta Circuit Bench at Port Blair, order dated 27 August 2019, in writ petition number 187 of 2019. The proposal of the Andaman and Nicobar administration dated 16 July 2015, forwarded by Ministry of Home Affairs to the Ministry of Tourism on 14 September 2015 was considered, and consultations were made with the Department of Personnel and Training, Department of Legal Affairs, and Department of Expenditure. The undersigned is directed to convey the approval of the competent authority for creation of 32 supernumerary posts for regularization of workmen working in Andaman and Nicobar administration, subject to the conditions laid down in para 4 of the Department of Expenditure OM dated 12th April 2017, which are reproduced below. Now, kindly see, my lord, the condition. Supernumerary posts, the following principles should be observed while creating supernumerary posts. The supernumerary posts are created for the purpose of accommodating the lien of a government servant who, though entitled to hold a lien against the regular post, cannot be accommodated because of non-availability of such a post. The supernumerary post is a shadow post, i.e. no duties are attached to such a post. Supernumerary post is created for a definite and fixed period. Since the supernumerary post is created for accommodating an officer till he's absorbed in a regular post, it should not be created for an indefinite period. The supernumerary post is personal to the officer for whom it is created, and no other officer can be appointed against such a post. It stands abolished as soon as the officer for whom it was created vacates it on account of retirement or is accommodated in another regular post. In other words, no officiating arrangements can be made against such a post. Administrative authorities should maintain a record of supernumerary posts, the particular of the individuals who hold liens against them, and the progressive abolition of such posts as and when the holder of the post retire or are absorbed in regular permanent posts for the purpose of verification of service and pension. Now, kindly see the order now. So therefore, my lord, this was the direction of the ministry, which was passed. My lord, will see again, come back to, if your lordships come back to page 248, third paragraph. The writ petitioners before this court were working as Group D staff on daily rates. Daily rates, my lords. They approached the High Court by way of a writ petition for regularization, which ultimately was disposed of by division bench by judgment and order dated August 27, 2019. This August 27, 2019 is also mentioned at page 234 in the order passed by the ministry. So, my lord, before the ministry's order, there was a direction of the division bench dated August 27, 2019. So, my lord, their rights or their entitlements, my lords, are basis this order of the division bench of 27 August 2019. Just as in the other case, it was the basis of the division bench's order, which I read, my lord, on January 22nd, 2007. So, my lord, may kindly have page 82, where my lords will find the order dated August 27, 2019. Kindly have page 82 of the paper book. This is the order, my lord. As opposed to the order of 22nd January 2007, which my lord I read in extenso. In the case of these petitioners, this is the order and direction of this honorable court. Kindly see, 29 petitioners have petitioned for issuance of mandamus directing respondent authorities, particularly Government of India, for creation of supernumerary posts to regularize their services within a time frame. Mr. Kumar, learned advocate, appears on behalf of the petitioner and submits the administration filed a report dated 16th August 2019, which carries correspondence already disclosed in the writ petition. He submits all queries raised by Government of India have been satisfactorily answered by the administration, and therefore and there should be directions as paid for. Mr. Mondol, learned senior advocate, appears on behalf of administration and relies on said report filed by his clients. It appears from the report that initially, by letter dated 18 March 2016, clarifications, information on 3 queries were required by the Government of India for further examination on creation of supernumerary posts for regularization of 32 workmen. 29 of 32 workmen seek creation, which has not yet happened. Last document enclosed in the report is letter dated 22nd January 2019, addressed by administration to Under Secretary, Ministry of Tourism. On perusal of the correspondence enclosed in the report, it appears the administration maintained throughout that some of the 32 workmen were engaged through employment exchange, others on daily rated basis, and therefore thereafter casual basis. They have since completed 20 years of service, as their services are essential to Directorate of Information, Publicity and Tourism to meet functional requirements of the administration. The Government of India, in following up with several queries, have indicated that it is not a fit case for creating the posts. In the circumstances, aforesaid respondent is directed to make his decision on the issue known within 4 weeks from the date of communication of this order. It is expected that the decision, if is in the negative, will carry reasons to support. So, my lord, the only direction here was that these were individuals who were working as on daily rated and casual basis for a period of 20 years. So they approached, they sought creation, they were not working on his vacant posts, there were no posts available. So they sought creation of supernumerary posts. The Honorable Division Bench said that you take a decision in the matter. Now, this has to be compared with the situation in 20 and in fact, the whole issue here was that there are no posts, so therefore you consider creating supernumerary posts. Now, my lord, supernumerary post, as I read from the ministry's direction, is only a temporary arrangement pending eventual regularization if it happens, or if they retire before that, or they vacate as a result of retirement. Now, this is not comparable to the decision of the division bench, where, my lord, there was a direction for mandamus was there. There is no mandamus in this case. The Honorable Division Bench only said you consider their case. In that case, there was a mandamus to frame a scheme and a scheme for absorption. The issue of supernumerary posts only cropped up because in the course of arguments, it was submitted that there are no sufficient number of posts. So therefore, the court said that no, there is a mandamus to frame a scheme for the regularization. There is a mandate passed by this honorable court that you have to regularize them. You cannot get away from that obligation by simply saying posts are not available. So you create supernumerary posts. It was in that context, my lord, that the Honorable Division Bench passed that direction. That does not mean that every time supernumerary posts are created, the benefits are to be given from the date of appointment. Because, my lord, supernumerary posts by their very nature are only meant for a temporary period. When there are no regular posts and maybe pending, maybe in future regular posts will be created, regularization will be done. But creation of supernumerary posts was in a very peculiar situation in the Home Guards case, where in very peculiar circumstances, the supernumerary posts despite the creation of supernumerary post, the benefits akin to absorption were granted. In this case, there is no prior mandamus of the court, there is no scheme for regularization, etc. So, my lord, simply their case was requested to be considered. Their case was considered and supernumerary posts were created.
Tell me one thing. August 27, 2019 is an order passed by the Honorable Single Judge, isn't it?
No,
And it's
August-
mentioned division bench by a
Strongly mentioned.
judgment.
Strongly mentioned.
Oh, it's wrongly mentioned.
Yes, ma'am. That is another. There's to be an inadvertent clerical error. So, my lord will see page 248 again. By such impugned order, the administration appointed the writ petition supernumerary post of workman with effect on 21st November 2019. Impugned that order does not provide any other financial benefits, etc. There is an order dated December 8, 2009 by the administration relating to home guards. There, the administration now directed regularization of home guards in the supernumerary post in lowest group D grade from the date of their respective initial date of deployment in the Andaman and Nicobar Home Guard Organization. Clause 3 of the terms and conditions of order dated December, and Home Guard also works in a different department altogether. Dated December 8, 2009, grants them certain financial benefits such as allowances, house rent allowances applicable to employees of similar categories. To my mind, writ petitioners before this court are similarly situated and circumstanced as that of home guards whose service were regularized by the order dated December 8, 2009 passed by the administration. This administration is not entitled to discriminate between similarly situated and circumstanced workmen. Petitioners before this court were also working as daily rated mazdoors, such as the home guards whose services were regularized. The orders of Supreme High Court or Supreme Court governing the parties do not prohibit or impede grant of benefits as extended to home guards. Benefits to the home guard were extended by administration subsequent to their order dated. This order, my lord, was an error, appears to be a mistake. Similar benefits as extended to home guards should be granted to petitioners before this court. Both the petitioners and home guards are under the administration. The administration cannot discriminate into Group D employees. In such circumstances, will modify to make it in tune with order number 298 dated December 8, 2009 governing home guards. In particular, administration will regularize the appointments from the date of their respective appointment as daily rated mazdoors. The administration will also extend the benefit of clause 3 of the terms and conditions. So, my lord, the Honorable Learned Single Judge has held that because home guards were granted this benefit, so the same benefit should be granted. However, my lord, will find.
1 minute. 13th March 2020, did you place?
Yes, my lord. 13 March 2020 is the impugned order in this case, page 146.
146. All right.
So, my lord will, firstly, my lord will appreciate that this order passed in the case of home guards, aside from my argument that was pursuant to specific directions of the CAT and the Honorable High Court, was passed, my lord, way back in 2009. And this is 11 years later, my lord, this order is passed in the case of the writ petitioners, which has, there is no connection between the two things, my lord, because regularization, my lord, is not a right. Regularization, my lord, there are several judgments of the Supreme Court also. My lord. The regularization, if there is no scheme, my lord, then ordinarily the court will not direct the regularization. Now, there is no scheme admittedly. A supernumerary posts were created for their benefit. They have been appointed to the supernumerary post. Now they want further relief. That further relief, unless there is a scheme, how can the further relief be granted to them? And their case is not the same as the home guards, because in the case of the home guards, there was a mandamus to regularize and absorb. In their case, there was no mandamus to regularize and absorb. So, my lord, supernumerary posts were only an ancillary issue in that case, because there were no sufficient posts. So, the Honorable Court said you create supernumerary posts.
And they are working in the supernumerary post with effect
Yes.
from 21st of November 2019.
Yes, yes.
All right. So your primary contention is that home guards and these DRMs are not at par and the same benefit can be granted.
My lord, very short issue, my lord. Issue is such, my lord. Admittedly, both were working as DRM under the Andaman Nicobar administration at different point of time. My lord, so far as home guard are concerned, my lord, the home guard regulation which governs the affair says that no home guard shall be taken into employment after 3 years. they allowed them to continue for years together, but did not promulgated any scheme to regularize their service. They approached the court. Now, in our case, we were working for more than 20 odd years. The department feel that our service should be regularized. They mooted the file. My lord, can you see the scenario? Because the administration has so mooted the file for regularization of our case by creating supernumerary posts. Therefore, there was no occasion for us to approach the court seeking for regularization.
Where is that document?
My lord, may kindly come to page 44. It was initiated in 2015.
44.
44, my lord.
You just show us that the home guards and the petitioners over here are at par.
At par, because my lord, both are under the same administration, two different wings.
Maybe under the same
Same administration, different wing. My lord, what is the issue? In both the case, they were working for a long period, but their service was not given regularization. Now, my lord, may kindly come to page 44. In our case,
28 August 2018.
my lord, 2018. Well, the file was mooted from 2015 onwards. There are documents.
Creation of supernumerary
My lord.
regularization.
18 number of thereafter detail, my lord. The ministry has asked these queries from Andaman Nicobar administration, and they have replied. And my lord will find they have in clear terms. They have said 18 of the casual were engaged through so and so, were engaged directed as per so and so. Now, my lord, may kindly see justification and functional requirement. Next page.
Yes.
It says that the service of 32 workmen are essential to the Directorate of Information, Publicity and Tourism for meeting functional requirement. Now, my lord, may see at the bottom, it says, keeping in view the various aspects as mentioned above, an essential functional requirement of so and so, manning the asset owned by the director of so and so, it is requested that 32 supernumerary posts may be created to accommodate these workmen and regularize their service. My lord, may kindly have a note of this. The word is not to give regular appointment, to regularize their service with department of so and so. Now, my lord will get it from the next page onwards. My lord, may kindly come to page 47 onwards is the date of engagement. They were engaged at different point of time on and from 1991 onwards. 91, 95, it is there, my lord. Now, my lord, here the file was mooted by the administration. Administration said you regularize their service by creating supernumerary posts. Now, my lord, on the basis of this, when, my lord, this was prolonged for years together, we approached the High Court saying that already there is a proposal mooted by the administration. Let the ministry take a decision. The court said you take a decision. If you negate the claim, you inform them accordingly. Now, my lord, on the basis of that, now I am on the orders issued by the ministry in both the cases are at par. Now, my lord, may kindly come to page 142. This is in the present case. My lord, since it comes under the Ministry of Tourism, my lord, first Ministry of Tourism accorded their sanction. Now, my lord, may kindly see.
Page 142.
My lord, the
21st
pagination is done in such a manner. 142.
Yes, 21st of November 2019.
My lord, it is Ministry of Tourism. Now, my lord, may kindly see, this is being communicated in compliance of the order passed in the writ court, by the writ court. Now, the proposal of the Andaman Nicobar administration dated 16 July 2015. My lord, may kindly have a note of this. 16 July 2015 forwarded by the Ministry of Home Affairs to the Ministry of Tourism on 14 September 2015 was considered and consulted with the Department of Personnel Training and Department. The undersigned is directed to convey the approval of the competent authority for creation of 32 supernumerary posts for regularization of workmen working in Andaman Nicobar administration subject to the condition. Now, my lord, this was the approval was accorded for regularization. Now, my lord, after this, my lord, may kindly come to page 145.
One
145 is the approval of the Ministry of Home Affairs. Now, my lord, may kindly see, this is 29th November 2019. It says, I am directed to say that in compliance to the direction of so-and-so, Mr. So-and-so has considered the proposal dated 16th July 2015 of the Andaman Nicobar administration
for creation of 32 supernumerary posts for regularization of the workmen in the Directorate of Tourism under the Andaman Nicobar administration in consultation. Pausing for a minute, my lord, this has to be read with page 196, wherein the approval for Home Guard was accorded.
Yes.
This is, my lord, of 9 September 2009. It says, I am directed to refer to letter dated on the and to convey the approval of the competent authority for creation of 326 posts of so and so for the purpose of regularization of Home Guard. Now, my lord, in both the case, the ministry has accorded the approval for regularization of the case of both the incumbents. There was no departure from both the order. Both are synonyms, my lord. There is no difference at all. At the time of implementing the said order, the administration, if my lord sees both the order, the administration says you have been given from the date of initial engagement. In our case, the date, if my lord sees page 146.
21st of November 2019.
My lord. Now, my lord, what I am on, my lord, admittedly, my lord, the ministry is the competent authority to accord approval. And ministry, while according the approval, has categorically considered both the case at par. Now, at the time of implementing the orders of the ministry, wherein only a formal order is required to be passed, while passing the formal order under the dint of the approval of the ministry, the administration shown discrimination. This is my case, my lord, which cannot be done. And if, my lord, the judgment which my learned friend relied, they are the, my lord said, my lord, that the ratio of Panto Chatterjee, why it was said, my lord, you take the service of an incumbent for years together and thereafter, while giving him benefit, you will not count the service which was rendered by him for years together, my lord. So, my lord, I say this is a clear case of discrimination by the administration, my lord.
As I just two very short submissions. One, my lord, the issue of regularization, my lord, is pending in another writ petition. And it's just pending before the learned single judge. Which was because that regularization was intended to cover all employees in the administration across the departments. The other submission is, if your lordships are not inclined to await that, my lord, then, my lord, I am requesting, I would like to cite certain judgments. If my lord keeps it for that limited purpose tomorrow, my lord, then I will cite.
Judgments for what?
Because, my lord, in my humble submission, when it comes to regularization, my lord.
It is not a regularization by learned friends.
One second, please permit me. Here, my lord, the court, my lord, the relief that the petitioner is effectively seeking from the court is relief additional to what has been granted under a scheme, or even if we were to, there is no scheme in their case, but if you were to treat that order creating supernumerary post as a kind of a scheme, then, my lord, the petitioner is seeking additional financial benefit which is not provided under that scheme. So, my lord, in my humble submission, my lord, there are recent judgments, my lord, where courts have consistently said that you cannot seek a mandamus for the purposes of an additional benefit or which is in the context of regularization. Because, my lord, it is not as if that the petitioners are also home guards. And despite there being a scheme for regularization of home guards, they have not been given benefit from the date of initial appointment. That would amount to discrimination. But, my lord, they are saying that there was a scheme 10, 50, 20 years back, 10 years, 11 years back. And under that scheme, certain benefits were given. 11 years later, you have passed a fresh order. And in that order, you should give those additional benefits which was given under a scheme which was 11 years back. My lord, that effectively they are seeking a relief from the court, that the court should give additional financial benefit than is given to them under the office order or the scheme which is promulgated for their benefit by the government. Now, my lords, in this context, my lord, there are certain judgments, my lord, which I pray your lordships may permit me to cite, my lord. So
But then you did not make this submission at the time of argument.
No,
In
my lord.
reply, you are making this submission.
No, my lord, those arguments have been raised, my lord. The legal argument, my lord. I'm simply.
Now, if you cite judgment, then your learned friend will.
My lord, already the matter was
distinguish.
posted yesterday. Now my learned friend knows that it is fixed for hearing.
Difficulty, I have agreed to
Now,
argue at the very instance.
one more thing, my lord.
The ministry, my lord, has, after the financial approval only, the order was passed. Financial concurrence is there at page 142. So they cannot say that there will be financial implication. The ministry, knowing well, they have given financial and expenditure sanction. On the basis of that only, the order has to be.
Expenditure sanction is based on the proposal given by the
Yes,
administration.
finance.
It will
No, no, no.
definitely not be that expenditure sanction has been given since the date of appointment and formal order is passed from the date from 21st November 2019. That cannot be the case. Now, only for this limited purpose, my lord, to cite a few judgments, my lord. May I have it tomorrow, my lord? I'm not.
Very well, tomorrow, please come. Heard detailed submissions made on behalf of both the parties. Stuff. Learned counsel representing the appellants seeks time to rely upon certain decisions in this regard. Stuff list tomorrow. No further matters today. It's already 1:10. No further matters today in the division bench.
Single, my lord, will sit from 2 o'clock.
बहुत ज्यादा हो जाएगा 2 o'clock में.
No, my lord, sometime, my lord. 1:45 at least. 1:45.
After 30 minutes.
Unless we have to actually order food and then food is cooked and then
Where from do you all
the
order?
canteen, my lord.
It's not readily available. You have to order and then only it comes. And where is the canteen?
Here only.
In the court complex.
Yes.
Tasteless. Arrange for tasty food.
1:45, my lord, please. Half an hour only, 5 minutes more.
All right, 2 o'clock in that case.
Opposition. So let this matter go to the next circuit bench. Because I'll be filing reply.
How soon can you file the opposition?
4 weeks, ma'am.
4 weeks? Was time granted earlier?
No,
This is the first.
first time.
So that let it come to next circuit, I think. Okay.
Is it your prayer or is it his prayer?
My prayer is, since he desired,
Since it is,
I am leaving to madam.
he is not making any submission. It is you who is making submission on his behalf.
No, my lord, I am requesting for 4 weeks, my lord, to file opposition. my lord.
Please come. Learned advocate representing the respondent seeks 4 weeks' time to file the affidavit in opposition. Stop. Next. On such prayer, let affidavit in opposition be filed within a period of 4 weeks. Stop. Reply, if any,
1 week.
within a week thereafter. Stop. Liberty to mention the matter before the available circuit bench.
Madam, the item number 22, Mr. Rajendra Singh is appearing. Let this matter be not taken up today. Let it be tomorrow. Item number 22.
Who are you for? You are representing on his behalf?
I am for the respondent. ma'am.
Is it required to be taken up tomorrow or can it go to the next circuit? I'll keep it in mind. Let us wait. Let it be called on first thereafter.
Madam, my engagement time, that's why I have mentioned.
I have recorded it. That a request has been made.
I'll not be there.
You are not
Except-
required to
except
be, yes. I have recorded that.
Item number on WPF 405 of 124.
My lord, I am seeking extension, my lord, to file opposition. One opportunity may be granted, my lord. Various factual issues are involved. And my lord.
What is the main issue?
Concerned officer has been transferred. It was a very checkered history, my lord. Opposition is required, my lord.
Very well. On the prayer of the learned advocate representing the respondents, time to file the affidavit in opposition is peremptorily extended for a period of
4 weeks. ma'am.
again 4. From August it is continuing. Or 4 weeks. Reply if any within 1 week thereafter. Stop. Liberty to mention the matter for hearing before the available circuit bench.
Item number 2. WPF 133 of 2020.
The writ petition has been allowed by directing the respondent authority to release the area dues of the workers strictly in accordance with the award passed by the tribunal. Stop. No prayer has been made for grant of interest, but the court has found that this is a fit case where the authority should be directed to pay interest to the workers on account of the inordinate delay in payment of their legitimate claim. And interest has been directed to be paid at the rate of 6% on and from 19th of February 2016, that is the date of disposal of the appeal before the Supreme Court, till the date of actual payment. If the payment, that is the arrear and the interest, is not cleared within 45 days from date, then the workers would be entitled to receive additional simple interest at the rate of 2%, that is 6 plus 2, 8% on and from the 19th of February 2016 till the date of actual payment. The writ petition has been disposed of.
Time frame, my lord, is given or
45 days.
no, my lord, for the initial payment is continuous.
Yes,
The
45 days. Within 45 days, you have to pay with interest, area plus interest. If you do not pay within 45 days, then additional interest. এখানে একটা ভুল হয়ে গেছে, এখানে 18 আছে, এখানে 19 আছে, চেক করে বসাবো কি হবে, গিয়ে দেখে সাইন করবো।
Number 3, WPS 672 of 2024.
My lord had directed us to take instructions, my lord, whether the list has been published. There is a
List
list,
for what?
their grievance was that their grievance was that list of eligible members have not been updated.
All right.
My instructions, it has been updated, my lord. I'm giving the.
Give a copy to your learned friend
Give it-
also. He also gets to know them.
Yes, yes. They still believe that it's a different fresh further action.
That is different.
No, my lord, this list exists in 2019. Let me place the case, my lord.
This is not an updated
this is
list.
updated, my lord. That is my instruction.
That list is part of my writ petition. My lord, may kindly come.
And my lord, there is an appellate authority.
Just a minute. My lord, let me place my case, my lord. My lord, may kindly see this list, which I have enclosed, my lord, at page number 32 onwards. Same list was
How many members?
400.
First is MS Malhotra, and it ends at
472, my lord. Yes,
72.
absolutely 472, my lord. In this also.
all same.
Same list. This is Deepak Lal Chand. This is of 2019. Now, my lord, let me place my case, my lord.
But this is the updated list as per my instructions.
That means it is not updated. This
Could
is
be
the
same
list.
members, my lord. If the eligible.
There,
change
there
in
may,
eligible-
yes, there may be change in the members.
There is no change.
No, my lord, there is no part that it's not that the 475 have continued to subscribe themselves. And
No, then it is all right.
it's done.
So you
And
mean to
secondly,
say
I
whatever is
expect
there in page
my lord,
32,
maintainability applicator, there's an alternative forum available. Very good. My lord,
whatever is there in page 32 to 39 is the updated list of the cooperative society. This is your submission,
Yes,
right?
and firstly, it's not maintainable with the alternative remedy available. And I'm grateful.
What
that
is the remedy that he is seeking? He wants publication of an updated list.
That's done.
This is the updated list.
Yes.
Kindly appreciate this particular possibly lady is lady. There has been a checkered history, my lord, as far as the society is concerned. Somebody is before this honorable court, that's not an issue because somebody is definitely playing between somebody in front. That's another factor, my lord. 5 years back, there was a series of litigation, my lord, regarding updating of this case. The society voluntarily, because my lord, there's a possibility some might expire, some might.
Yes, certainly.
Of the society.
5 years, there must have been changes.
For substantial number of years, there was no update. So we did we did a survey. It was published in paper and everything was then ultimately out of around close to 5,000, only 475 came forward and got themselves verified, my lord. This updation of the membership to the extent of 475 was finally informed, my lord, and an election was conducted 5 years back, my lord. And the other membership lapses, my lord. There is no provision under the regulation, even if there was a provision under the regulation for the 5 years. And 5 years preceding that 5 years, this particular lady never came forward for updating her membership 5 years back or during the currency of these 5 years. During the currency of these 5 years, there is no representation to the society. There is no representation to the registrar of cooperative societies under regulation 55 of the Andaman and Nicobar Islands Cooperative Societies Regulation. Let my learned friend demonstrate that he or she had approached any of the authorities with any grievances. One cannot just come and knock the doors of the court, madam.
Yeah, very well. Let me see what the prayer is. To update the membership of the petitioner, to enable the petitioner to cast a vote.
My lord.
What steps have you taken for getting your membership updated?
My lord, can you see? This is 2013 where updation was made. There are altogether 5,000 persons as a member of the said society. My lord, may kindly have a look to this. 5,000 and odd. to 2013. Now let me place my case, my learned friends will get an opportunity, madam.
We have not filed opposition.
I am seeking for an interim order, whether
The election process has been notified.
now, my lord, 5,000 and odd, my lord. What happened, my lord? 2016, the said society was superseded. When the said society was superseded, subsequently, the administration,
Was it by any order of court?
no, my lord, that
Alright.
was superseded. Subsequently, in the year 2018, the administration, there is a time frame within that the administration has to conduct the election. Now, my lord, may kindly come to first annexure at page 24, annexure P2.
Yes.
Now, my lord will find this, it is a notice for revision, updation of list of membership. Now, my lord, in this time, this is not done. Now, my lord, may kindly see what is written there. This is to bring to the kind notice of all bona fide members of the Central Cooperative Society that in terms of bylaws number 33 of the society, it is mandatory to maintain a list of members and roll of the society who are qualified to vote at general body meeting, and to bring such list update before each meeting of the general body, and to supply copies of such list to such persons on such fees as may be prescribed in this behalf. All bona fide members are therefore requested to furnish the requisite information in prescribed form along with supporting document duly attested by so and so, so and so. So, my lord, there the process was initiated by the administration for updation. This time it was not done. Now, what happened, my lord? This was done in 2018. Thereafter, also the election was not taken place. My lord, one person filed a writ petition before this honorable court. My lord, may kindly come to page 25. My learned friend at that point of time appeared for the authorities. Now, my lord, may kindly see page 25. This is 27 September 2019. For the society, or yes, this is an application filed under Article 226 of the Constitution. The petitioner before this court is a shareholder of the Central Cooperative Society. The response number 5, society was established in so and so, and at register the provision of so and so. Learned counsel appearing for the parties submit that the writ petition may be disposed of without insisting authority to file affidavit in opposition. On the consent of the learned advocates, counsel appearing for the party, the petition is taken up for hearing. Now they say that it is not maintainable. Now, on their consent, it was taken on the very first day. The grievances of the petitioner is that administrator is going to hold the election for selecting the members of the managing committee of the said society on such and such date without fulfilling the mandatory requirement contained in the bylaws of the said society. Learned counsel appearing for the petitioner submit that necessary direction may be issued to the administrator to hold the election after publishing the list of the members in terms of the bylaws of the said society. It was contended by her that the last date list of members was published in 2013. My lord, I have handed over to my lord 2013. It is her specific contention that in the meantime, some of the members might have expired or might have left this island. As such, there is necessary to prepare a fresh list. After ascertaining the actual status of the members, so and so. Now, my lord, the writ court, she has further submitted that necessary direction may be issued to the administration not to hold the election on such and such prior to finalization of the list of the members as per the bylaws. Learned counsel appearing for the response number 1 to 4 submit that at present so and so is acting as the administration. Learned counsel will submit that the preparation of fresh list is needed to be conducting fair election. My lord, this is the submission made by the authority, that is the response for whom Mr. Satadu is appearing. From the submission made by the learned counsel appearing for the parties, it appears that it would take time in preparing such so and so. In view of the above, I am disposing of the writ application by giving direction to the present administrator to hold the election after preparing a fresh list of the eligible members in appropriate case after observing all formality including deletion as well as induction of the members. Now, my lord, so far as induction of the member is concerned, my lord, in accordance with bylaw, the entire exercise. My lord, so far as the order whereby the court allowed induction of members, my lord, that was carried in an appeal before the division bench by my client. Not this client, by some other client, my lord. Now, my lord, may kindly see the division bench judgment, my lord. Now, my lord will find. My lord, may kindly come to page 29.
Yes.
Fifth paragraph, Mr. So and so, learned advocate appearing for CCWD and Mrs. Nath so and so appearing for the response number 1 and Mr. Mandal appearing for the administration do not join issue with regard to the proposition of law
laid down and so, as well as the applicability of the present case involving pari-material provisions, we have no hesitation to hold that. Not be sustained in law. So, my lord, that part was set aside. Now, my lord, by that time I was approaching the court. We did not able to update our membership. Now, my lord, in this said appeal, I just orally made a prayer before the court. My lord, may kindly see last paragraph. Although much has been submitted by Mr. So and so with regard to the validity of the notice, to the effect that no cutoff date should have been fixed and all the members should have been allowed to participate in the election. My lord, pausing for a minute. Entire episode was pertaining to election only, my lord. Now, as and when conduct upon the production of document relating to identity and other supporting document, we are not impressed. Not impressed. Due notice was published, but unfortunately the appellant did not respond on time as well as within the extended time. We see no reason to interfere with the notice that have been issued by the administration. We make it abundant. Thereafter, the court said within. Now, my lord, this appeal. First of all, the appellate court said that no further induction. Second, I have made a verbal prayer that, my lord, by this time it was the notice period was expired. Therefore, I may be allowed to update my. The court said nothing doing. There is a cutoff. There was a cutoff date. You cannot now. My lord, this was confined to the election. Thereafter, at least I could have been updated. Now, my lord, the similar issue was raised by other members. Now, my lord, may kindly see the order of the registrar. Initially, I approached this court. The court said you file before the arbitrator so far as updation is concerned. Now, my lord, may kindly come to the order of the respondent number 1 at page 43. This was filed by one of the members for updation, my lord. Now, my lord, they have taken into account. My lord, may kindly see. Kindly come to page number 48, para 9. It says, my lord, by the deadline on 23rd November 2019, only 472 members have updated their membership. Accordingly, a final list of 472 eligible members was prepared, and those who failed to update their membership were removed from the list. In the meanwhile, Murugation has now thereafter, my lord, Murugation and others have tendered appeal together with an application for leave as well as stay application. Thereafter, my lord, the judgment of division bench was reproduced. Hearing both the sides, the learned judge stated that cutoff date fixed by the authority so and so. The court dismissed so and so dated so and so following observation by the administration and cannot be mentioned in the bylaws in the absence of so and so. The membership updation para 12 process was conducted strictly in compliance with the order so and so, and a final list of 472 eligible member, not 4963 as previously reflected in the audit report. The general body meeting in his letter dated resolve the correct the audit report and reserve the share capital of so and so. Now, my lord, para 15 is important. That it is to make clear that no one, including the petitioner, came forward and approached the management to update their membership or refund of their share like other 472 when sufficient time for updation was allowed. The argument of the petitioner is wrong on basis so and so, and therefore it is most simply submitted that the so moto management has not initiated any action. Now, my lord, this observation and thereafter, if my lord comes to next page onwards, the first paragraph deals with the order of the writ court. Second and third paragraph deals with the order of the division bench. And thereafter, my lord, now, my lord, may kindly come to next page, my lord. Now, an entire thing was on the basis of the division bench judgment. Page 51 says the honorable division bench has made its observation in order that due notice was published, but unfortunately so and so. Thereafter, my lord, the honorable court on so and so passed order, remarks so and so. In view of the above, as petitioner did not come with clean hands, there is no. Now, therefore, in exercise of the power, I so and so, after giving reasonable opportunity to the plaintiff and after duly considering the matter hereby order, the plaintiff request for updation of his membership identity card cannot be entertained as he failed to comply with the provision. The CCW is not obliged to update the plaintiff. Now, my lord, they have played with the order of the court to their convenience. I have approached the court only for the limited purpose, and the entire episode was confined to the election. Now, on the basis of this, my lord, and this order was passed on 9th November 2024. So, till date, they are not allowing anybody to update. Now, my lord, kindly come to paragraph number 9 of my writ application, my lord.
So just tell me one thing.
My lord.
Everything is in terms of the order passed in the year 2019.
Yes, my lord.
So
Absolutely.
from 2019 to 2024, what is happening?
No, they were not up, my lord. What happened thereafter? This Murugesan, he approached. Then nothing was done. He filed a writ petition. Writ court said you approach the authority. He approached the authority. Thereafter, the authority rejected it, saying that we cannot do that. He approached the lieutenant governor. After approaching the lieutenant governor, once again we filed a writ petition before this court. This court said you filed an arbitration application before the arbitrator, and this is the award of the arbitrator.
But this is in respect of one Murugesan, somebody else.
What we are on, what I am on, my lord. I say that only by taking the shelter of the judgment of the division bench, they say that it cannot be updated at any point of time since the division bench has said that the cutoff date is over. Whether it can be.
1 minute, 1 minute. Where is your application seeking updation?
My lord, they are not accepting any application. They, my lord, may kindly appreciate the situation.
They are not accepting.
They are not accepting, my lord. My lord.
Where have you mentioned in the?
That specifically I have not, my lord, they are not, my lord, even managing committee is there. They are saying that you allow all the members to update there. They are saying that only 2 persons are running the show, chairman and secretary.
What is the registrar doing?
Registrar is passing this order, saying that in terms of the division bench, you cannot be updated. Now, my lord, may kindly see 4 pleadings, my lord.
1 minute.
My lord, for the purpose.
1 minute, 1 minute. The order of the registrar has been read out.
Yes, 9th November 2024. my lord.
It appears that
It's in relation to somebody else. Yes.
not only in relation to somebody else, in relation to an order which was passed in the year 2019.
Yes.
So from 2019 till 2024, no updation will be done. How can that be
my lord,
possible?
The stage at which the petitioner has approached is exactly the stage at which Murugesan had approached this court, and this court passed a detailed order, my lord, on 11 January 2024 in similar circumstances, my lord.
January 2024.
Kindly see, my lord, the order.
Relegating the parties, my lord, before the.
Kindly see the order. This is exactly same cause of action.
This is Murugesan, I can understand.
I'm not on that, my lord.
1 minute.
The point, the legal question, my lord, which is being asked.
Why are you standing in the way of the updation? You are the society. Why we?
Kindly,
When was the cutoff date? When was the cutoff date for updation?
Number 2, one has come with voluptuously in the green hand. This gentleman Murugesan.
No, we are not concerned with Murugesan.
If somebody is relying upon document of Murugesan without disclosing as to how she gets these documents of Murugesan, it is evidently clear that she has been projected by Murugesan.
Try to understand something. This is one K Raja Lakshmi, right? The submission is that you are not accepting the prayer for updation.
He is not applying.
If you are not accepting, what can be done?
She has to demonstrate.
All the members are approaching, they are not accepting.
And why will you not accept? I don't know. Is it your stand that you are accepting the membership
We have
claims?
completed the updation.
When?
We have published it in the newspaper on 30th November 2024.
Please show what you are relying on. The newspaper clipping.
Updation is one thing, induction is another thing. I was a member, or rather she was a member.
She is a member.
Wait 1 minute.
He was a member. He was a member of the society. 2019, when the updation took place, she doesn't come forward. She doesn't come.
How do you say she was a member? Was her
She is a
name?
member, my lord.
1 minute. Was her name ever updated in the list of members?
She doesn't subscribe. He doesn't come for renewal of a membership. The membership lapses.
Did she ever have a membership?
He had initially.
Is in the 2013 list that has been produced before the court, is her name there?
Well, a 2013 should be there.
Yes.
Show me. Name is there.
All the members.
Right. Now you say because, very well, because of non-payment of subscription, her membership lapsed.
Verified.
Very well, her membership lapsed.
Lapse.
This is your submission. Now, you will not allow a member who has not subscribed.
Member.
I am a
She's
class A
still
member.
there. She's what type of a
I am
cooperative
a
society
class
is
A
this?
member, my lord. I am still a class A member.
What
Only
type
I
of society is this?
This is a
Society of-
society registered under the
Of
1948. This was formed, my lord. Under the
for what purpose? Purpose of,
Yes, my lord. It is running. Now, my lord will find this dividend and all, we are not getting. And my lord, whatever.
there may be many issues with the cooperative society. We are not looking into it. You want an updation of the list.
List for the purpose of casting election and all. My lord, I am asking myself, suppose my learned friend is the president of our bar. Some of the members were left on the last occasion. My friend will not allow them to update and cast their vote. Whether this argument, my learned friend particularly, who is a person who is president of this bar from last several years, and all
No,
such
thing
type
is,
of.
No personal example.
thing,
When you are.
No,
Kindly please consider.
thing is, I do not understand why from 2019 till 2024 further list will not be published.
Question of continuity, we are raising it, my lord. But law is very clear. If I don't raise it at the initial stage, I can't raise it later on, my lord. So my lord, right, that as well, I favor against me. Then, because otherwise I should not be debarred from taking this point subsequently, my lord. Regulation 55 of the Andaman and Nicobar Islands Cooperative Regulation.
Yes, please show.
Provides. And the judgments.
My lord, may kindly have this order once because it's identical circumstances. There is no decision at all for them to challenge, my lord. Kindly see this order, my lord.
My lord, this was dealt in the order of 9th November.
Kindly.
Second page, my lord. Ask whether the petitioner is a member of the cooperative society or not is the core issue.
Which one are you
Second
reading?
page, my lord, of the judgment, my lord.
Oh,
Because regulation 55, everything has been dealt here, my lord.
yes,
1, 2, 3, 4, 5, 6 line from top, my lord.
yes.
Whether the petitioner is a member of the cooperative society or not is the core issue.
Hmm.
The petitioner filed a representation dated 23rd June 2023 before the secretary of the cooperative society, who is also the registrar of the cooperative society.
See, this is not the case here. There is no representation from the petitioner.
That is even
That is
worse.
this is worse.
The petitioner,
This is self-destructive.
whether is a member or not,
That's
that
the
is
issue.
also not the issue.
That's the issue, my lord. He says she doesn't remain a member any
I am
further.
a class
Our
member.
whole-
till date.
Our whole petition is relying
In
on.
that case, that opposition be
I
filed.
am asking for an interim order because my lord, if election, my lord, same order was passed by the writ court on the earlier occasion where all the parties have given consent. My lord, may kindly see that I have.
Yes, you've placed it, you've placed it.
Yes, page number 25.
When is the date of the election has not been declared? It's
29th of December.
These are the documents. my lord.
29th of December is for some other purpose.
29th of December is
Page.
election to the managing committee is one of the agenda, page 52.
I am giving the date.
Page 52. Clause number 6, my lord.
The annual general meeting will be held
Yeah, it's in the meeting when this election
It's-
takes place.
in the
In the
meeting.
meeting. That's the procedure of the.
Clause 6.
My lord, this updation was done and notified by the.
And isn't the election by way of secret ballot or anything?
My lord, in the event there is no consensus, like then and there it will
All
take
right.
place. Then and there it will take.
That's why they don't want to induct anybody as a.
And the returning officer, my lord, and others have been appointed, the schedule is.
You know, whatever may be on the earlier occasion also same thing was there, this could have.
This particular Murugeshwar, he initiates an arbitration proceeding before the arbitrator on same subject. The arbitrator registrar passes an award which is challenged before the Lieutenant Governor. Now, seeing that the appeal is not getting disposed of, this lady is being projected and made available with documents. Who never comes to the society, never approaches the society.
Frequently occurring, everybody is on.
Please come. The petitioner claims to be a member of the Central Cooperative Welfare Society Limited. Stop. Her name appeared in the membership list for the year 2013, but thereafter her name has not been updated in the membership list published by the society. Stop.
2019, and she didn't come forward for updation.
The last date of updation of the membership list is in the year 2019. Stop. The cooperative society has published a notice in the newspaper mentioning that the annual general body meeting of the society will be held on 29th December 2024 for election of the managing committee. Stop paragraph. The petitioner submits that till an updated membership list is published, comma, she will not be in a position to cast her vote. Stop. Next. Prayer has been made by the petitioner for a direction upon the society to publish the updated list. Paragraph. Learned advocate representing the society submits upon instruction that the petitioner is no longer a member of the society. Stop. She never approached the society with her prayer for renewing her membership. Stop. The writ petition at the instance of the petitioner is not maintainable. Stop. Paragraph. Learned advocate representing the respondent number 1 relies upon the membership list of the society published in the year 2019. Stop. Next. The continuation. The name of the petitioner does not appear in the said list. Paragraph. Notice of this court has been drawn to the provisions of the Andaman and Nicobar Islands Cooperative Societies Regulations, 1973, and the Andaman and Nicobar Islands Cooperative Societies Rules, 1784. Stop. Rule 55 of the regulation deals with disputes which may be referred to arbitration. Stop. It mentions that Rule 55 within bracket 2 within bracket C mentions that any dispute arising in connection with the election of any officer of the society shall be deemed to be a dispute and is to be referred to arbitration for a decision in the matter. Stop. Next. There is nothing on record to show that the petitioner ever approached the society with her prayer for updation of her membership. Stop. Only after the notice of the election was published in the newspaper on 28th of November 2024, the instant writ petition has been filed. Stop. Next. At such a delayed point of time, it will not be possible for the court to decide the issue of membership. Stop. The petitioner prays for an interim order. Stop. Paragraph. I am of the opinion that the petitioner ought to approach the arbitrator in terms of the regulation mentioned herein above for immediate relief in her favor. The writ petition stands disposed of.
Like in that case, my lord, within a time frame, my lord, so that this process.
In the event In the event the petitioner approaches the registrar of cooperative societies. Today is 10th, by day after tomorrow, by 12th. 2024, the registrar shall consider the prayer of the petitioner and if found expedient, may pass necessary interim order in her favor.
And dispose of within a time frame. Otherwise,
Get the interim order first, you never know where it will end up. Take back all the documents, whoever supplied. This will go back to Mr. Chakraborty and this too.
And number 4. That I am part of the petition. I served upon all. It's the original on 5th December. In person, it's all. My client is posted in Mayabandha.
Yes,
Yeah,
where is your affidavit of service?
That is the reason I'm submitting. My client is posted in Mayabandha. So I could not file the affidavit of service.
And what is the immediate relief? Grant of recommendation of.
Asking for immediate report.
Very well, please come.
Kindly come to page 30, madam.
Sir, let somebody appear.
Already served.
Let somebody appear at least.
They are not appearing, madam.
Why will they not appear? They are appearing in each and every matter
I
and
served upon them on 5th, madam.
I understand. There is a representation at page 30.
Madam, page 30 is there, representation. It was disposed of. Kindly see how many pages representation? 5 pages representation.
Yes,
Lot of things I have taken in the representation. In
yes.
2 line, madam, it was disposed of, page 36.
Page
11th
39th August 2024. Page 36.
2 line order.
And the prayer made by you, video such and such shall be looked into soon after receipt. It has not been disposed of. It is pending consideration. Will
No,
be looked
recruitment rule is already notified. I will show that.
after receipt of the notified recruitment
Page
rules
65,
from
see,
September 2024.
page 65. Starts from page 63.
63.
The recruitment rule was already notified. And then Sanjay is passing this cryptic order.
1 minute. Page 30, your first request for implementation was the uniform allowance.
Deputy Commission.
Then
Anomaly,
anomaly regarding
And,
pay fixation.
pay fixation.
What has that got to do with the recruitment rules?
I fail to understand. The recruitment rule is already notified, page 63.
How does it,
Correlate.
how are you concerned with this recruitment rules?
I don't know, Miller.
What you don't know? You were filing the writ petition, you should know
this
why are
recruitment
you?
was submitted by the office of the Session Judge, district Session Judge. Page 36. There is no relevancy. 63 may be seen, Miller, already recruitment rule was notified long back.
Let somebody appear. For the administration, who will appear?
I served, everybody I served. Chief Secretary, Session Judge, Secretary Law, Secretary Finance. We cannot appear.
No, sessions judge you cannot appear, then the secretary law.
We can appear.
Law is there, finance is there,
Everybody I served.
chief secretary is there,
Let a copy be given.
director of accounts
sir.
and budget is there. Sir, a copy upon
Copy may given, give me a.
the on record so that he can take in. Very well.
Served upon the-
Then. Let a copy be given.
None appears on behalf of the respondents. Stop.
Even after service, Miller.
Despite service.
This has
Stop.
been
Let
received.
Yes.
Let affidavit of service be prepared and filed on the adjourned date. Stop. Learned advocate for the petitioner is directed to serve a copy of the writ petition to the advocate on record. What is the name of your on record?
Mr. Rakesh Kumar, Mr. Rakesh Kumar.
Mr. Rakesh Kumar, learned advocate, who usually represents the administration before this court. Stop. Mr. Kumar shall take necessary instruction in the meantime. List in the next circuit.
My lord.
What is the interim order you are praying?
Not
Nothing.
saying anything, Madam, let
Yes.
them file the affidavit, I will serve the copy, no problem.
Let them go
Department is
through it.
judiciary in this matter.
Let them go through it first.
My lord, then may not be.
All right, let's list on 16th.
Subject to him serving a copy to Mr. Rakesh Kumar.
Obviously,
Was already served, even then I will serve. No copy may be given. The department is.
you get in touch with the authorities to,
Why not?
if it is there, then you can collect a copy from your client also.
Here we go. Subject number 6.
Item number 5, WPS 68 P.N. of 2024.
My lord, one female Mrs. Nag is appearing on behalf of the petitioner, my lord. I pray for this not today, my lord. Let this matter be fixed tomorrow. She is engaged in court number 2, my lord.
Why don't you start?
My lord, I am not prepared, my lord.
You
Let
should
this
remain
matter be
prepared.
fixed. Also, I will come.
Very well. On the prayer made on behalf of the learned advocate representing the petitioner, the matter stands adjourned till day after tomorrow.
Okay.
Get yourself prepared. I'll hear you.
Item number 6. WPS 68 P.N. of 2024. Here also I serve, my lord.
Nobody is here?
I don't know, my lord.
Same department?
No.
Different?
Secretary is there. Work board is also there. Work
Board.
I serve.
Which board?
Work board.
Walk board. Who appears?
Information copy has been served to them, but if not supplied to me, let it come tomorrow, I will take instruction.
Only disposal of my representation which is pending.
But I have not
Let
seen.
him go through the copy. None represents the respondents. List day after tomorrow.
If it is possible tomorrow, my lord.
If your learned friend can come tomorrow, then tomorrow.
Tomorrow I will take instruction.
Very well, tomorrow.
Please. Item number 7, WPS 689 of 2024. Petitioner.
What is happening? Why is the respondents not appearing? You are there? Very well.
One private respondent is there, my lord. He is residing at Teresa. It's very difficult to serve him, but order was passed by the respondent.
No, but then if you have implemented somebody, some private
I tried to
respondent,
serve upon the council. He flatly refused. He flatly refused.
what can be done? Without the authority of the client, how can the council
Authority is
accept?
appearing. I'm challenging the impugned order passed by the authority.
Maybe.
Page 19.
The private respondent waives a service.
I'm submitting a letter. He is residing at Teresa Island. Service could not be affected upon him.
No, affidavit of service.
I am not.
Not ready.
I served copy.
Copy of the writ petition is yet to be served upon the private respondent. Stop. List the matter in the next circuit. Service in the meantime.
Short matter, my lord, can be disposed of.
What can be done?
I am not saying anything.
Serve
against
and
private
come.
respondent. Item number 8, WPS 637 of 2024.
I am for the petition. My lord, the identical issue has been decided by Honorable Justice Mr. I.P. Mukherjee in another writ petition. And Mr. Vinu Kumar was the petitioner in that. I requested him to provide a copy of that so that we can go through that.
What is to be done? I'll adjourn it
Adjourn.
till next circuit?
Next, sir.
Till the next circuit? By consent of the parties? There is a
Let them file.
direction.
No, there is no direction.
There isn't any direction. All right. No direction. The issue in question is required to be decided upon exchange of affidavits. Stop. Let affidavit in opposition be prepared within a period of
Weeks.
3 weeks. Reply, if any, within a week thereafter. List the matter. After the stipulated time period, a report of the administration was supposed to come. Who is for the administration? Will you be there? Where is it? Very well. The report by the administration has not been filed. Stop. The affidavit. Now, affidavit shall be filed by the administration on the in terms of the direction passed here in above.
Item number 9.
Lordship, item number 9 to 12, Lordship, I have not received any copy, Lordship. So can it be fixed on Friday, Lordship? I will take instruction and come back.
Let the petitioner come. Where is the petitioner?
Item 9.
If the petitioner is not appearing, then what can be done?
Let it be on Friday, Lordship, in the interest of justice.
Stop. List day after tomorrow. Service in the meantime. Friday, make it Friday, 13th.
Lordship.
Service in the meantime.
Item number 10. WPS 683 of 2024.
I have not received any copy, Lordship.
Service not affected. Why? Your learned friend is there. Serve. Very well. List on Friday.
Lordship.
In the meantime.
Item 11.
Same order.
Same.
12. WPS 687 of 2024.
12, Lordship, today morning I have received the copy. I will take instruction and come back on Friday.
Friday. List on Friday. Learned advocate for the respondent authority shall come ready with necessary instruction.
Deeply obliged, Lordship.
Item number 13. WPS 300 of 2021.
My lord, in this matter, Mrs. Nag is appearing on behalf of the petitioner, my lord. That this matter will be fixed tomorrow, my lord.
Are you sure she's for the petitioner and not for BSNL?
To respond and respond.
Where is the petitioner? Are you aware what is the application for? Let me see the application one.
My lord, we have already filed the notice. Would he have to appear? But I think it's like Vijay Kumar, sir. Advocate Vijay Kumar, sir.
What is the application for? Modification. And this is filed by BSNL or by whom? Who is the applicant? Recovery.
Regarding modification, my lord.
Who has filed the application? Applicant, respondent. Respondents with petitioners. The respondent's application. Where is the proof of service of this application upon the other side? Somebody was there yesterday or day before yesterday. This matter was called on, no? Yeah.
The copy was received here.
Yes.
Kumar, Vijay Kumar.
Where is he? He's gone for medical treatment. In the morning it was mentioned, in the evening none appears, then matter will ex parte order. What is to be done? There is a direction for passing ex parte order. And the petitioner is not here. There are many private respondents also over here. Did you serve them? An accommodation has been sought for on behalf of the learned advocate representing the applicants. List the matter day after tomorrow. Let notice be served upon all the non-appearing parties.
Item number 15, WPA 133 of draft 2.
How long will it take a hearing matter?
Paper court, my lord, matter.
Oh, that means it will take time. Yes, I see it.
My lord, I directed them to come back with the details, my lord.
Detail, yes. Produce evidence in support of the submission that the workmen performed their work continuously for a period of 240 days in a year prior to the retrenchment. What is this?
My lord has asked me to produce the bank statement, ma'am.
Right. Where do I get?
But from page 1 to 11 is of 1%.
1 to 11 of 1%. All right.
My lord will get at page number.
Give a copy to your learned friend.
I have to examine, my lord, and come back.
1 to 11.
They have made the payment. What
No,
examination
but
they will do? Page number 1.
No, because he has to take instruction.
Let him take
I'll
it
take
because
instruction.
they have made the payment.
Yes, yes. Show me Rajesh Paul that he received payment for 240 days in 1 year. Please show.
My lord, page number 1 is the period for which bank statement was taken, my lord. First page, my lord. At the right hand side, my lord, you find that statement is from 6th January 2018 to 31st December 2021.
Yes.
Now, my lord, may kindly see first page at the bottom, my lord.
Yes.
26th January 2018. This is the payment made to him. My lord will find mandate Andaman and Nicobar. Thereafter, my lord, may kindly come to page number 2, 28th February 2018.
28th of February 2018. Yes.
My lord. Thereafter, my lord, may kindly.
These are the payments received.
Yes, my lord. It's written mandates. Andaman. Nicobar.
Yes, man days.
Thereafter, page number 3, my lord.
Did you check up? Does it come to 240 days?
My lord, my clients are having from 2012 onwards.
Yes.
Since my lord has asked that from the last
Last,
date of retrenchment,
yes.
that 240 days,
Right.
I have produced 1 year, more than 1 year.
Yes, yes. Is it 240 days?
Yes, my lord. My client, my juniors have checked. I have checked 4, 5, my lord.
4, 5.
Yes, but I have highlighted, my lord. So
All right, all right. And the calculation also
What's
comes
the
to
demand?
240
Next
days.
demand.
480 rupees per day,
Yes.
possibly.
at that time, the first minimum wages was 480, maximum 24 to 25 days they work. So they get 10,000, 9,000 likewise.
All right.
That is there.
You
come back.
please
I'll come
go
back.
through it and see whether 240 days criteria is met or not.
My lord, from my client also, even they maintain attendance register was sent by the junior engineer of the electricity department. On the basis of that only payments are made. My learned friend is having all the documents.
I will come back. I'll ask the department to give instruction and come back.
Very well.
That could be the number.
A detailed compilation has been filed by the learned advocate representing the petitioner.
My lord, with regard to 30%, total there are 41, my lord. But within this short period, some are out island and we did not able to.
Very well, I understand.
No, but then my lord, for everyone it have, so it
It
is
has to be
finding
there.
school.
It has to be there.
Learned
But
from
this
it,
is one, this is only for Rajesh Paul.
That I will.
Is the writ petition only regarding Rajesh Paul or
No,
other
no,
such?
41. On the other day also it was fallen from my lord. My lord may kindly come to.
Oh, he is the president.
Award, my lord. It is that, my lord.
All right, he is the president. All right. Learned advocate representing the petitioner, evidencing the fact that the workers were in service for 240 days in a year. Stuff. Copy of the compilation has been handed over to the learned advocate representing the administration. List on day after tomorrow.
Let it be, my lord, one day more, my lord.
13th,
Day after tomorrow is
12th.
13th, let it be 13th.
13th. I will be left with hardly any time.
In
to
any event, they
prepare
have
the
to give for
judgment.
the remaining people also, my lord. That has not been produced.
See whether there is anybody.
No, I'll
remaining or
do
not.
that. No, I'm
Yes.
just saying that
My
because
lord, I have inquired from my clients, my lord. The junior engineer certified attendance is being taken and only thereafter payments are made. I have been handed over with that.
Obviously, otherwise how can
Yes,
payments
this
be
was not
made? They will
produced
not
before
make
the labor
payment.
code. I will take instructions.
Take instructions.
I will take instructions, my lord. 13th.
13th.
Item number 16. WPA 100 of 2023 with item number 17, 18, 19, 20.
Shiv Balan is there. Yes. An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. List the matter in the next circuit. Till 21. Same
Even-
order.
Number 21.
I pay for the respondent.
Same order.
Same.
Yes, till 21.
Obliged, madam.
Item number 22.
22 accommodation has been sought for.
Yes.
You want to file? Is it
Oh,
ready for hearing?
Yeah, ready for hearing.
An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. List in the next circuit.
And then he had requested for not today, my lord.
I understand, but I don't think this business of the court will permit to take up any
Right.
further hearing matters.
Item number 23. WPA 91 of 2024.
Time for the petitioner, just one day time today, not tomorrow.
Private respondent.
Because I received some notification which I will place.
And
Yeah,
you
I
will
could
place, they will take instructions. List in the next
Tomorrow.
circuit.
As
Accommodation has been sought for same order, next circuit. By the learned advocate for the petitioner, not on behalf.
on
by
my
the-
part.
Item number 24. WPA 276 of
I'm
2024.
appearing for the. आप किसके लिए? आप-
Only for Vijay Kumar, I pray for next circuit, my lord.
Yes. Prayer has been made for posting the matter in the next circuit. List in the next circuit.
Item number
Let
25.
it be at their request, madam.
Yes, on the request of the petitioner.
24, appearing.
On the request of the learned advocate for the petitioner.
25. Item number 300. WPA 300 of 2024.
I pay for respondent, my lord.
Your Lordship, in this particular matter, Mohammed Tabakar appearing behalf of the petitioner. I just pray this matter can be taken up next circuit because we have to file a reply, Your Lordship.
Check up whether opposition is there.
Your Lordship is filed here.
The affidavit in opposition is on record. Stop. Learned advocate for the petitioner seeks time to file reply to the same. Stop. Let reply be prepared and filed by 30th of December. Stop. List in the next circuit.
Your Lord. Obliged.
Highly obliged, my lord.
Item number 26, WCS 301 of 2024, with item number 27.
Item 26 pleadings are complete, 27 they are yet to file their reply.
Yes.
Reply file kar their copy may be served.
Copy has been served, sir. Dhanalakshmi. Dhanalakshmi.
How is XESS pronounced? Says. Yes, what is to be done?
Let this matter be fixed tomorrow, my lord. She is engaged in a court number. And we have to file a reply.
You have to file.
No, copy has need to be served, my lord. So that is item number.
Did you file it? Is the
20.
reply on record?
27, my lord.
27 and reply also.
26, 27? नहीं? Opposition আছে 26 से? দুটো আছে। 26 से reply नहीं?
26 we have been served reply, 27 we don't have it.
না এটা 26 দুটোই আছে 26 did you get the reply?
Yes, 26 we have got.
All right, 27 reply
Not served.
and not in the record also.
Please check, maybe it has not been filed.
27. Item 27, 26, record an order. Prayer has been made for adjourning the matter for the day. Stop. List the matter in the next circuit. 27, record an order. The affidavit in opposition is on record, but the reply is yet to be filed. Stop. List the matter in the next circuit. Stop. Reply may be filed prior to the adjourned date.
Item number 28. 318 of 2024.
That I am for the petitioner.
My lord, reply has been
July 2024. Huh?
reply has been filed in the registry, my lord.
Copy
I
is not-
am giving you. Reply है ना?
Copy of the affidavit in reply has been served.
Lord, without annexer, it was served.
I will.
Opposition. It is the opposition.
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 It is not on record.
Not on record. I shall let it be fixed on day after tomorrow. I will check and come.
Lord, it was supplied without.
I
any
will
annexer.
give. Annexer is there, not there, no?
Annexer is not there.
Not there.
October 24. Affidavit in opposition as directed to be filed has not been filed till date. Stop. Let the matter appear in the next circuit. Stop. The pleadings must be over by the said date.
That my client is facing a lot of difficulty because of this.
What is to be done? See, your friend has prepared the opposition served upon you without the annexure. Nothing is there on record. How can the matter be heard?
At least Friday it will be fixed. No.
No, no,
Right.
it's not possible.
Monday, no.
No. Yes, next.
Obliged.
Item number 29. WBA 327 of 2024.
Reply is not filed by me.
Where is the petitioner?
Mrs. Nag is appearing on behalf of the petitioner, my lord. We have
Reply.
to file a reply, my lord.
Learned advocate for the petitioner seeks time to file affidavit and reply. Stop. List the matter in the next circuit. Stop. Reply may be filed prior to the adjourned date.
Okay.
Item number 30.
30, my lord, this is similar to the earlier matter. One other matter, my lord had heard where the review is pending. with Respect to order passed in a similar matter which they are relying upon. So, my lords, in that view of the matter, it may be adjourned.
Oh, it was adjourned till the next circuit.
Yes, ma'am.
All right. Do you have a copy of the order?
Similar matter.
Similar matter order? Acha.
Review, my lord, they are relying upon an order which has been challenged in review.
And
Therefore,
the review is pending.
Yes, review is pending.
List the matter in the next circuit. So the parties shall come ready for hearings. Next.
Item number 31. WPS citizen of London.
My lord, I am appearing for the petition. I am seeking an extension to file my affidavit in reply, madam.
On the prayer of the learned advocate representing the petitioner, time to file the affidavit in reply is extended. Stop. List in the next circuit.
Obliged.
The reply may be filed prior to the adjournment.
Item number 32. WPS 339 of 2024.
I'm appearing for the petitioner in this case. Reply affidavit of reply is filed today. I have given, I have served them today.
Will you start?
Reply has been served. We are ready, but if whatever, if they want next circuit, like it. I'm not.
What is your submission?
No, it can be taken up.
Please start.
My lord, this applicant is a small time contractor.
Yes.
He runs a business for construction to earn his livelihood. So he participated in a tender floated by the respondent authorities and he became the lowest tender. The validity of this tender was up to January. It is admittedly, it expired on 26/12/2023. Till such time, his tender was not accepted. So the validity lapsed on that day.
You said you were the lowest bidder and your tender was
Yes.
not accepted. What does this mean? These are two contradictory statements.
No, I was the lowest bidder
Yes.
and they were
The finalization did not take place or what?
award of work was
Work order not issued?
not issued.
All right.
I was lowest in the bidding process
Yes.
and they have to accept the tender within 3 months.
Right.
The 90 days period is the validity of the tender. So they have not done so by the time the validity lapsed and they have issued the acceptance letter in the month of March. When March, I didn't respond to their acceptance letter and in May, they forfeited my AMD. So my grievance is this year.
The validity period starts from the date of issuance of the work order.
No, my lord, I'll just take you to the page number 21 of the writ petition. Yeah, here, this is tender scrutiny note.
Yes.
Prepared by the authorities themselves. So in the last line, this last line, tender validity expires on 26/12/2023. Because my offer is valid only up to this period, this date.
No, I think this is a wrong interpretation you are making. Show me that your tender was accepted.
It was accepted after this period. My grievance is that they have not accepted till when my offer was valid. My grievance is that they have not accepted the tender. And then this suddenly they accepted it in the month of March when I was not well. I was under medical treatment.
It is better you try your luck in the next circuit. Right. A copy of the affidavit in reply has been served upon the learned advocate in presenting the respondents in court today. List in the next circuit.
I'm grateful.
But you have to overcome this hurdle.
Item number 33. WPS 342 of 2024.
I appear for respondent authorities, my lord.
22 years checkered history, your lord. It's take time.
We have filed a reply, ma'am. Opposition.
Ready, matter is ready.
Yes, start.
So this is 33 numbers. I have not brought the file today.
You have not brought the file and you are ready. What does this
No,
mean?
no, as well, your pleadings matter is ready. I am submitting, it's a long
Oh,
pending
it's a
matter.
checkered history.
Check-
Very well.
That's right.
That is enough indication for the court to post the matter in the next circuit.
That was my intention.
Where is your reply? Reply is not on record.
No, it's filed, you not
That ones are not received.
received.
I have received.
Yes,
The affidavit in reply is
It was
not on
filed.
record. Stop. List in the next circuit. Let the affidavit in reply be placed on record.
Obliged, my lord.
Item number 34, WPF 403/124.
My seniors appears for the petitioner, my lord. I pray just not today, man. It can be taken up tomorrow.
Just not today? Why just not today? Just not this circuit?
Not today.
Why not today? What is the matter about?
My lord, the petitioner is asking for regularization. Your lordship may kindly go through the order dated October 4th, 2024, my lord.
Yes, passed by.
Justice Procedural.
All right, in this matter,
This matter.
yes. As for serving
Because,
maintainability
point has to be
maintainability
decided
point.
Whether this writ petition is maintainable at all.
Yes.
Because the writ petitioner asks for regularization absorption, the service matter.
Service matter, where does the petitioner work? Daily rated Mazdoor, not today, on the prayer of the
Obliged, my lord.
learned advocate representing the petitioner, list the matter tomorrow.
WPF 417/2024.
My lord, I am appearing for the petitioner. Today I have received the copy of the opposition. So I'll be using.
Is the opposition on record? That's it. The opposition is on record. Stop. Let reply to the same be filed within 30th of
My
December.
lord, my lord,
List in the next circuit.
obliged.
Item number 36, WPF 423/2024.
Lord, here I am for the petitioner, my lord. Here I have filed my reply today and have given the copy. Let it be fixed tomorrow for hearing, my lord. The very short point is involved, my lord, because prior to selling of the property, we have to take no dues, none encumbrance. That has been rejected.
No dues?
And none encumbrance from the revenue authorities.
All right.
That is the point, my lord.
And
That-
who did you sell the property to? Is there any private party?
No, my lord, that is
No.
that is the agreement. First, have to take, prior to selling of the property, have to take all these documents, my lord. Thereafter.
So you
only I can-
you want the authority to give you this document?
My lord, that was rejected.
That was rejected.
Rejected. I'm 70 years old,
Let,
ma'am.
let me see the file.
My lord, today I'm not ready, my
Not
lord.
ready?
Let it be tomorrow, my lord. Let it be tomorrow.
Very well. On the prayer of the learned advocate for the petitioner, list the matter tomorrow.
Obliged.
37, WPF 435/2024.
Yes, Your Lordship, my lord, I appear for the petitioner of Mr. Prasad. This matter, my lord, I was to file my reply to the opposition of the respondents. But my lord, my client has been indisposed. I'm praying for an extension of time to file the reply.
On the prayer of the learned advocate representing the petitioner, time to file the affidavit and reply is extended till 30th of December 2024. List in the next circuit.
Deep.
Item number 38, WPF 417/2024.
And for the respondent works board.
Your Lordship, Mohammed Tabet sir is appearing behalf of the petitioner, Your Lordship.
So
So the respondent have to file their reply, Your Lordship.
respondent will file reply from when?
Approved in opposition, Your Lordship.
Yes. But this is a hearing matter, which means that the opposition has been filed, or what? Is the opposition there?
You have not yet filed.
Not filed?
Not yet.
Why? Let me see.
Opposition is not filed. हम लोगों को कुछ कहना है?
Opposition, the pleadings are not over yet. Stop. Let affidavit in opposition be filed within a period of 4 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matters for hearing after completion of the pleadings.
हमको इंस्ट्रक्शन में
तो आप बोले नहीं।
है ना, ready है
39.
39, I am for the respondent matter.
Mr. Halder was here just now. Is it ready?
Oh, yes, ma'am.
Opposition and reply filed.
Reply has not been filed.
Check whether it's there on record.
Opposition is filed, reply has.
Reply not filed. The affidavit in opposition is on record. Stop. List the matter in the next circuit. Affidavit in reply may be filed prior to the adjourned date.
Item number 40.
But none for the petitioner.
Your Lordship, my senior advocate Anjali Nagar on behalf of the petitioner, Your Lordship. On the previous date, there was an order to file affidavit in opposition by the respondent authorities.
Has it been filed?
Not yet been filed, Your Lordship.
Matter to grant extension.
On the prayer made by the learned counsel in presenting the respondents, time to file the affidavit in opposition is extended for a period of 4 weeks. Reply, if any, be filed within a fortnight thereafter. Stop. Liberty to mention upon completion of affidavits.
Objection. Item number 41. WPA 510/2024.
Yes.
I have filed my opposition on 6th November, my lord, the department.
I require one week.
The opposition is on record. Stop. List in the next circuit. Affidavit in reply may be filed prior to the adjourned date.
Item 42. WPA 546/2024.
In this also, I have filed my affidavit in opposition yesterday.
Yesterday.
Before the registry.
It's there. None for the petitioner. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. The affidavit in opposition is on record. Stop. List the matter in the next circuit. Affidavit in reply may be filed prior to the adjourned date.
Right, Your Honor.